Okay, thank you. So Senate Government Operations, it is Thursday, April 8th, and we're going to start with the OPR bill. And what I'll do is we'll introduce ourselves because you're not usually with us, so you probably don't know who we are. We'll introduce ourselves, and then if you want to talk to us about your issue in the OPR bill. And we will be joined by Senator Clarkson, who is currently in the Rules Committee and is just trying to transfer. So I'm Jeanette White. I'm from Windham County.
Hi, I'm Anthony Polina from Washington County.
Brian Collimore from Rutland County.
Aisha Ron from Chittenden County.
So would you like to tell us the issue that you have with the way the pharmacy section of the OPR bill is currently constructed?
Yes, again, thank you for the opportunity today. So my name is Michael Duteau. I am a pharmacist by training. I'm president of the Vermont Association of Chain Drugstores. And I would like to preface my comments with the fact that we have been very engaged with OPR on this conversation. It's been very productive, very professional. We have a great deal of respect for the director. We've had some input, and we are okay with the first section, Section A, that's proposed, but we are still at a place where we agree to disagree on Section B, the part that defines drug outlets and chains. We feel that the practice of pharmacy is just that, the practice of pharmacy, and chains and drug outlets should not have separate regulations. Again, as a pharmacist who's practiced in hospital, independent, and chain settings, it was always upon me and my professional judgment to ensure that I practiced in a safe and professional environment, and the regulations should apply to all pharmacies independently.
And so how would you change it? Just
We feel that Section A, along with other existing regulations, provide the tools necessary to OPR to adequately and accurately enforce what the intent of the law is. We feel that adding in B confuses the matter and, again, separates two types of practice when in reality they're both pharmacies.
okay. Any question for Mike? And I don't see Lauren with us yet. Any questions for?
I'm
Mike?
honestly trying to find in the bill where
I am as well.
I think it is.
There's Lauren.
It is Section 5, I believe. Did you find it?
No, with all due respect, the copy I have is all about mixed martial arts. I can't find anything about pharmacy.
If you look at H289.
As passed by the House. There should be two bills posted for H289 today. One of them is the amendment we've been looking at. The other one will say as passed by the House. And that's where Section 5 is.
There's only one up right now, unless let me refresh. There we go. Thank you.
So Lauren, do you want to comment on that? About why we would have separate discipline procedures for chain drug stores?
Sure. I apologize for being a little late.
Oh, that's fine.
For the record, Lauren Hibbert, Director of the Office of Professional Regulation. The office and the Board of Pharmacy engaged in a survey of pharmacists in the fall after concerns came up with our office on the workplace conditions of pharmacists. We have always had some workplace conditions, some rules about the workplace conditions for pharmacists. For instance, pharmacists are supposed to take a meal break. That has been in our rules for some time. It is a patient safety rule, not a workers' rights rule, but it is a patient safety rule. I think it is important to remember what pharmacists do. Mr. Duteau clearly knows what pharmacists do. He is one, and and takes his role very seriously. And I appreciate, I've had many conversations with him and I know he takes his role seriously. But pharmacists, not only do they count and dispense medication, that's the most simple parts of their job. They're really responsible for drug utilization, counterindications, making sure that the prescription is appropriate for the diagnosis. They do, after the work that this committee did last year, they now are providing vaccinations, birth control. There's lots of things that pharmacists are able to do now. They have a very important clinical role. And the pattern that we saw after our survey was that the expectations put on chain pharmacists, people who work in chain pharmacies, is unreasonable compared to what is placed on people, pharmacists working in other environments. And that corresponded with what we had heard, which is what made us do the survey. So when I was discussing this section of the bill on the House side, I submitted the results of our survey, and I'll do that today to this committee so that you can see the trends that we saw. People not being able to go to the bathroom, not being able to have a meal break, people pumping, breastfeeding mothers pumping behind the counter because they did not have a place to pump, nor did they have time to pump. So some really serious concerns were brought to our attention. We do take our responsibility seriously to make sure that the workplace is safe for the pharmacist and for the consumer. And in pharmacy, we have a unique responsibility because we regulate both the pharmacy and the people who work within it. So we've always had oversight of the environment, plus the people who work in the environment. I'll say that this bill, it certainly was the unprofessional conduct is not, it's not addressed only to chain pharmacies. The unprofessional conduct would apply in non-chain pharmacies. It doesn't call it out, but the piece that does is if we see a pattern in one, then we can start to apply it to others with notice and due process. So that if we see, I'm going to make up a Harry's drug chain. I'm making up a drug chain just because I don't want to cast aspersions. If we see Harry's drug chain has a problem in Brattleboro and we provide notice that we think it's a problem in Brattleboro and in White River and in Montpelier and in Burlington, then we can proceed without having to do separate investigations and prosecutions. And this is so that we can start to address systemic problems as opposed to just playing whack-a-mole, which is where we are right now.
So how do you, I guess, define, I'm thinking, for example, of, would this apply also to, I think that the Montpelier pharmacy, which is called something different now, actually owns the Brattleboro pharmacy. I mean, we have a hotel pharmacy, which is completely independent, but we have Montpelier, I think, owns the Brattleboro pharmacy. Would that be considered a chain?
Yes, they're both Kenny's.
Oh, but they were bought out by Kenny, but they weren't originally when Montpelier bought Brattleboro, they weren't part of Kenny. They were just two pharmacies, but owned by the same place. So would they be considered a chain in that case, so that if you saw problems in Montpelier, you could also apply them to Brattleboro?
Yes.
Okay. So it isn't chain in the sense that we think of as the chain pharmacies, but it's if an entity owns more than one pharmacy.
Exactly. So it is if it's more than one location owned by the same corporation, entity, or person.
So the regulations aren't different. It just allows you to, if there's problems in one, it allows you to open an investigation into the other sites owned by that same entity. Where with an individual independent pharmacy, there wouldn't be a need to have this because you're investigating them and there's only one of them.
Right, but we still could use the first half of this
Well, yeah,
section,
yeah.
which
No,
against
I mean-
them. But this second half of the section, we would use if we saw evidence of a corporate policy that is a directive not from the pharmacy manager in a particular pharmacy location, but is something from a higher entity. And it goes into the systemic problem of how we regulate pharmacies. We don't regulate CVS or Kenny or Walgreens. We regulate CVS 1950 located in Berlin. I don't know if that's the number of the CVS in Berlin, but that's how we regulate. We don't regulate CVS. We regulate the location of the retail outlet. We regulate the building itself.
Okay, got it. Senator Collmore?
Thank you, Madam Chair. And Lauren, forgive me if I'm misinterpreting this, but it seems to me that you're painting the chain with a pretty wide brush. Why? There's almost a presupposition that if there's a problem in Rutland and it's owned by the same company, that there would be a corresponding problem in Brattleboro. I guess I don't understand why you still would just not go to the problem. And if it's only one store, even though it's owned by a chain, you deal with it just like you would deal with an independent pharmacy. Maybe I'm missing something.
No, Senator Collmore, if we found that there was a problem and it was exclusive to one chain, then we would pursue action as we would an independent. We wouldn't automatically jump to the remainder of the stores. What the times that we would go to the remainder of the stores is if we found in the course of our investigation or inspection a corporate policy that is making those individual outlets act in a certain manner. So there are all sorts of policies that that our inspections unit have bumped into, or that pharmacists have told us, yeah, I wish I could do that differently, but that's the corporate policy. And we're finding themes throughout the state of institutions that pharmacy manager in one and pharmacy manager in location 2 and pharmacy manager in location 3 say, yeah, this is corporate policy, so I can't not do this. And so right now our option is to pursue action against each individual pharmacy. And some of our pharmacy outlets have multiple locations. So then we're looking at 15 actions, 15 investigations, 15 inspections. And we see that the problem is not the particular location, but is a policy that's coming from a location that we do not regulate. And so this is a way to put the consumer on notice that this is a theme, a problem. It's a way to, it quite frankly has gotten quite a bit of attention from corporate pharmacy. So it's a way to get the corporate pharmacies' attention that they need to change their policies and pay attention to what Vermont rules are. So it's a way to give the regulator some more power to affect change faster.
Okay, I'm still not 100% comfortable with it. Maybe I could ask Mike to respond.
Yeah, please.
Again, thank you. We've had some, what I consider to be really respectful dialogue around this, and we still do agree to disagree. You know, from our perspective, we went through the survey. Community pharmacy is predominantly the main practice in Vermont, with chains being much more numerous than independents. Hence, we, of course, were the majority of the respondents. But in looking at some of the complaints, there are things that we need to continue to do better, not as a chain, not as an independent, but as a profession. And a lot of the issues are not the direct result of a corporate policy, but there are some things that better policies and better practices could do to help solve those issues. I apologize, I'm on a green light switch. But in any event, you know, from our perspective, we feel that should be able to suffice, and there are other mechanisms that would be able to achieve what OPR is looking to do without sanctioning all of the outlets. With that being said, I want to make sure, you know, that I accurately convey that we are very respectful of the intent here, and we very much would engage after one finding to ensure that we are headed in the right direction, if that's the best way to say it. I mean, I think, again, everybody here is on the same page. At the end of the day, it's about improving safety and access for the patients, and that's what we both want. Both of our groups want that to occur. I think we just have a divide in the middle as to how to best achieve that.
So I just have a question for you, Mike, I guess, about if it is a corporate policy that is determining the actions of the pharmacy in Berlin, it also is determining the actions of in Brattleboro and in Ludlow. So why would we ask for those same issues exist in each of those places if it is a corporate policy? Why would we have to put OPR through doing in this case, three investigations instead of just one?
And again, that is a great question, and that certainly is not our intent. Where we feel that there perhaps is a disconnect or a divide is we're not aware of any pharmacy that has a policy saying you can't take a lunch break or you can't use the bathroom. But there are interpretations by pharmacists who are required to use professional judgment to make decisions. There are different interpretations of policies from one store to another. And I think that's where we're most concerned is, a pharmacist may decide this is what it means for my pharmacy and how I practice, and another pharmacist may read that differently. That's incumbent on us as operators to ensure we're having conference calls, we're properly communicating with our teams to ensure that we are consistent in how we practice in all of our sites. But again, one policy may not be interpreted the same way by pharmacists across the same chain. That's difficult for us to envision as a regulation that is just applied back to us in a flat or a broad brush capacity. But I do think it's incumbent for us to be able to engage in conversation. Once OPR brings this to our attention, there's due diligence on our side to make sure that this is not something that's occurring in all of our outlets.
Lauren?
I respect what Mr. Duteau is saying. We have tried his approach, which is to talk to corporate about the issues that we've seen, and we have not seen substantial shifts in some of the problems that we're seeing. So I can't speak to his particular, where his employer or his, group, but we have had this problem repeatedly. We have tried to address it in every way that we can. Our inspectors correspond with corporate pharmacy executives all the time to try and resolve whether this is the policy or not. And it's been a challenge. And so that's why we sent out the workplace survey. That's why we're here with this proposed solution. I do think there's due process here. There's notice here. There's the ability for the corporate entity to come in and represent its group of retail outlets and explain how this is an independent pharmacist's decision and not the pharmacy's policy. And it would have to have due process attached to it. So that's an important piece, something that, I think this approach is unique. I don't think this has been tried in another state, as far as I can tell, this type of approach. But I think it might be the most successful to address the problems that we're seeing.
Other questions, committee, or comments? I mean, I guess we're not holding the chain drugstores to a different standard.
No.
What we're doing is saying that if there is something that seems to be a corporate policy, that it's going to affect all of them. And so when you come across that, what do you initially do, and where does the ability then for the corporate to come in and say, well, this is our policy, this is to be interpreted by the pharmacist? What actual action do you take once. Can you explain that a little bit, Lauren?
All right, be happy to. So some of these issues will come up for us on an inspection. All of our pharmacies in the state, whether they're chain, independent, hospital, compounding, are inspected once every 2 years. So some of these issues will come up in that inspection process. There is always a fair amount of document gathering and fact gathering in the inspection process. They would be referred if there was a significant problem. The first approach of our investigators is to educate and remediate. Sometimes that cannot occur in the inspection process, and a case is referred to our enforcement division. That's the first way that we get cases into the enforcement division from pharmacies. The second is consumer complaints, and we've had a large uptick of consumer complaints about pharmacies in the last couple of years. So in either case, once the complaint walks in the door, whether it comes from a consumer or whether it comes from our inspection division, we will investigate it. We have an investigators assigned. They then go out on a fact-finding mission, talk to the pharmacists, gather documents. If needed, they would talk to the corporate entity. And then if a pharmacist would be assigned to that case as a board member, as an I-team member, a prosecutor would be assigned to that case. The prosecutor would make his or her independent discretionary decision on whether or not to prosecute the case after hearing the advice of the board member. And then that case would be charged in a charging document that would have to outline what the concern was, how it violated the law, and what remedy they were seeking. And then that is a public document that would be shared obviously with the parties, which would be the pharmacy. And the pharmacy is part of the corporate entity. So the corporate entity would have notice. And then it would be scheduled for hearing, but before the hearing, there's a full discovery process, which can include depositions and exchanging of exhibits. There's quite a bit of time to do some fact finding before there's a hearing. It is not a slow process, and it's not a process where people can't be heard.
So the process, but there's a lot that happens before there's public knowledge about. I mean, you're investigating, you're talking to the pharmacist, you're talking to consumers, you're talking to the corporate headquarters, all of that, trying to figure out exactly what is going on before you decide whether there's actually a case there to prosecute.
Yes.
So,
and
go ahead.
I was just going to say that we don't prosecute a fair number of cases. We decline to prosecute a fair number of cases because we think the investigatory process in and of itself served its purpose.
So I guess I don't understand what the issue is then if all of this is done before there's, I mean, I wouldn't know if the two Walgreens in Brattleboro are being investigated or not before there's actually a case, before there's a decision to assign a case to it and to prosecute and charge. So many things can be worked out before I, as a customer, if I am a customer, am even aware. So I guess I don't understand the issue then, because you would find out in that investigating, in that pre-charging, you would find out whether there was, if the corporate headquarters said, nope, that's something that they can interpret, it's up to them to figure out how to do it, or the pharmacists, all 5 of them say, nope, we can't interpret that. We've been told this is the way it is. But you'd find that out before you ever got to a charging place, right?
Yes, we would find that out, or at least we would come to a determination on our own of whether we thought that had happened. But then even after we charged it, there's the opportunity for the retail chain to come in and say, your assumption is incorrect. Your understanding of what's happening is incorrect, and here's why.
Okay.
So they can come in and rebut what we have found.
Okay, yeah, that's a little, when I was thinking about this originally, and I spoke with Heather about it, I was thinking that it was different standard that was being applied. But
It's a different disciplinary standard, I would say. That's where I think it's different. I want to be respectful to Heather's understanding, because what's happening is, instead of doing an independent investigation, let me say this, if we have a problem with a mental health counselor, we investigate that mental health counselor, and we don't assume that another mental health counselor has the same problem, just because they're both mental health counselors. But the difference between a mental health counselor and a pharmacy is that there's someone in here, up between the two of them, that's telling the pharmacy A and pharmacy B what they need to do, how they need to, the technology they need to use, the notification to patients they need to use, the number of prescriptions they need to dispense, the number of vaccinations we're trying to get done in a day. That's not done at the pharmacy A's decision making. That's done by the corporate entity.
Brian, I think you had, Senator Polina?
I did.
Senator,
How many chain pharmacies operate in Vermont? Do you know?
I do know, but I don't know off the top of my head.
Okay.
Let me take a look at something and I'll get back to you. I do know that.
And then the second question that I have, out of those, have you ever found a situation where every single last one of them is doing the same thing based on a corporate decision?
Yes.
Okay.
We know of problems that come from a corporate decision that are radiating through every chain that is that corporate decision maker.
And you've attempted at some level, Lauren, to contact corporate headquarters and say, hey, look, we got a problem here. What can you do about it? And you're saying that they're either ignoring you or you can't resolve it? Huh. Okay.
I do know that there were tons of complaints from Bennington and Windham counties. I believe it was, I don't remember which chain it was, but I know that there were a lot of, and the poor people who were working in the stores were, I mean, they were caught in between, because I do know that because we experienced it down here, and I know in Bennington, Senator Sears has talked to me about that they experienced it a lot. So Senator Collum, Polina, you had a question, I think, and then Senator Clarkson.
Yeah, I think I do. And I understand from Lauren's point of view why it makes sense to do it this way. But I'm not really sure what the downside is to the pharmacy, to the chain pharmacies, to tell you the truth. Partly is you don't want to be painted with a broad brush. Is it just sort of a pain in the butt because you have to deal with all these things? I just want to really kind of what the bottom line is. Why is it a bad idea? Mike, I guess.
Sure. So I can provide some insight, and I will disclose, Lauren's aware of this. I'm licensed to practice both in Vermont and New York. I spent 15 years on the New York State Board of Pharmacy, and we managed 5,000 individual locations without this type of policy. I will say, and I mean this as a sincere compliment, I think the communication with Vermont OPR is at a much higher level, and obviously there's an opportunity for us to engage at the same level. One of the concerns that we have is a black and white piece of paper or an email with a policy. That's understandable. And again, I don't think that's what we're talking about. We're talking about interpretations of corporate communications. A good example is Lauren brought up how many vaccinations or how many prescriptions you fill. My company doesn't have a policy around that, right? The business comes in, but we do know how many prescriptions you fill, whether or not you have a drive-through. If you're doing immunizations, that does play into how much payroll we can give the store manager to work with. And that's the concern, is that amount of payroll may work very well for a pharmacist in 20 of our locations, but we may have a pharmacist in one of our locations that perhaps practices differently or can't keep up, and despite adjustments or interventions, they can't make that work, or they're having a hard time. If an error occurred and OPR went in and they said, well, it's because of a corporate policy, that's why I made the error, we would have a hard time with that then being applied to all of our other sites. And again, that's probably the exception, not the rule, but that is why we are raising our hand and saying we don't think it's as simple as just 3 bullet points in a policy. But in all fairness, there is a lot of discussion that occurs in the process. OPR is very good at outreach from my personal experience, very reasonable in having discussions. And again, we've had a lot of productive dialogue about this to this point currently. But that's an example of something I feel could be pulled into this and applied as a corporate policy when in reality, it's really at the practitioner level.
Lauren, I thought you wanted to say something, but before you do, I just want to. I think there's a part of the bill that says that discipline will only be enacted if the conduct was found to be at more than one location, more than one outlet. So it seems like you have to find that there's at least a bit of a pattern before you take action, disciplinary action. But I'm sorry, you were going to respond.
No, Senator Polina, you're making the point that I was going to say, which is there does need to be a pattern, and Mr. Duteau's company could come in and say, this is a problem unique to this location with this particular pharmacist. We don't have the problem in other places. And that the corporation could do that at multiple points in the inspection, in the investigation, and certainly at the hearing. So there's multiple opportunities to make the point that he would be entitled and appropriate to make, which is, this is not a problem that's universal or because of the corporate policy. This is because we have an employee who can't meet our expectation for a whole variety of reasons, and we're trying to remediate that.
And you could do that at the moment you found out there was a problem in one location. There would be the chance for corporate to say, that's a problem of that location. It's not a policy of ours.
Yes, and that conversation is happening now with investigations and inspections. We have those conversations with the corporate entity, and they do explain that it's not corporate policy. It was a particular pharmacist's mistake or error, and then we don't pursue action against the pharmacy itself. We pursue it against the particular pharmacist. So that type of investigation, that type of trying to filter out who is responsible for the conduct that may have harmed a consumer or could harm a consumer if allowed to continue, we're doing that analysis now. What this changes is if we find that it's because after our investigation or after our inspection and investigation, if we find that it's because it's a corporate policy, and we find that it's happening in multiple locations, then we don't have to open up a case and investigate a case in every location in the state. We would notice every location. Every location would have due process rights and would be able to come in through the corporate entity. And we would have that discussion on a much higher level than we're able to have it now, in a more formal way than we're able to have it now.
Okay. Sarah Clarkson, I think I saw your hand up.
No, thank you. I'm just, getting up to speed. I'm sorry I was late. I apologize. Where I was in Rules Committee. I actually support this. I think this is good. And as Anthony pointed out, it has to happen in more than one location. There are more, just to answer Brian's question, there are more than probably 5 chain drug stores in Vermont, and then there are all the food stores like Price Chopper or Hannaford's or wherever that also have drug come home. So there are probably 8 or 9 different entities that this might apply to, is my guess.
It could also apply to health systems, right? If I understand correctly, if a hospital operates multiple pharmacies.
But we don't have, right.
Yes, I'd like to ask one more question, if that's okay.
Sure. Sure,
I mean, if I'm part of a chain, let's say you find some kind of unprofessional conduct, and you find it at 2 or 3 stores that are part of a chain of 10. The other 8 or 7 that you didn't find it at because you didn't need to go through all that, they're going to get a notice of enforcement of some sort. Can you just give me an example of how that might work? So I'm a pharmacist down in Brattleboro, and I'm going to get a notice of an enforcement telling me that others in my chain have done something wrong. I mean, I'm just wondering how that's going to be played out. Not a very articulate question, I know, but you get my point.
Okay. I'm struggling with my light today. I apologize. I'm in the dark, but
there seem to be a lot of light challenges today. There's a light that's too smart and is outsmarting the owner, and there's
That would be me.
Yeah, it also could be related to the fact that it's actually sunlight coming in these days. You know?
No, it's lovely. It's a lovely problem to have, but
Right.
I'll go off camera and try and remediate it at some point. What will happen is when a pharmacy is registered with the state, the contact information and the corporate agent is attached to it, the person who receives notice if charges are filed against it. So it could be a pharmacy manager for the outlet, or it could be someone within the corporate entity. So that person, whoever is identified, will get notice of the charges, and then will be given notice of how to respond to the charges. And you have to respond within 20 days. Does that answer your question, Senator Polino?
But if I was not one of the 2 or 3 that you actually investigated, I would get this notice in the mail or somehow that says I'm being held responsible for something that I didn't do, that you don't know if I did it or not.
I think the important distinction is it's not a person that we would be saying you did this. It's the location. Okay. So it would not be the pharmacy manager. It would be the location of the pharmacy, the building and the entity of the pharmacy.
Okay.
Because you could take action against an individual pharmacist in a chain or not in a chain without impacting the pharmacists in the other locations in that chain.
Absolutely, and we do. So currently, perhaps not currently, I think in the last couple of months, we had a pharmacist who was diverting narcotics from his pharmacy. This unfortunate, it happens. It clearly wasn't any of the pharmacists who worked with him's fault. It wasn't the chain's fault. It was just his misconduct. So we charged him. We didn't charge the place where he worked. Now, had we found that they had no system to control, count, or manage narcotics that enabled him to divert and made it easier for him to divert, then we might have charged both, right? So that's the analysis that we do when we find unprofessional conduct that's occurring in a facility where we license the facility and the pharmacist.
Senator Colmore?
I don't mean to prolong this any longer than it needs to be, but what exactly does your notice say, Lauren? And again, with all due respect, it still feels to me like you're making a chain guilty before you've done due diligence. I mean, isn't your job to look at each pharmacy and not to make an assumption that just because it's part of a chain that there's malfeasance going on in all of the branches? In other words, if, to Senator Polina's point, if I operate and again, I'll just make up a name, a Bryan drugstore, but I'm not doing whatever it is that is the problem, but 3 of my other branches are, what is that notice going to say when I get it as an innocent person? Your chain is under investigation, or how does that work?
So looking at the statutory language, and to be fair, we have not had a notice like this to date. So I don't have an example that I could give you. I could give you an example against a specific outlet that's within a chain, but I can't give you an example where I'm trying to do this because it's a new statutory construction. But what would happen is B1 says that the state must provide with in a specification of charges that unprofessional conduct occurred in one or more drug outlets, then that the unprofessional conduct, so that's fact one. Fact two that has to be alleged is that the unprofessional conduct is attributable to pharmacy or pharmacy business-related policies, procedures, systems, or practices of the chain, whether or not those practices manifested in unprofessional conduct at each individual location. And the state would have to argue that the imposition of disciplinary sanctions or conditions against all drug outlets in the chain are appropriate to protect the public. And I think it's the third factor that will be the most debated of, yeah, this was our corporate policy, but it's happening at one, it's causing a problem at one, but not all. Or no, that this happened at this location and we have a corporate policy, but what happened wasn't the result of the corporate policy. That's factors 1 and 2, and I think those will be debated. But that third factor of that a condition or a warning or a sanction needs to be imposed against all locations will be the topic of debate and motion practice in a contested hearing in front of the Board of Pharmacy, and ultimately appealable to an appellate officer within our office and the Supreme Court. So I think that that's going to be, we're going to have to develop the standard of when that is as this language is becoming enacted and then starting to be utilized. But I think that will be the most common area of debate. And I think there probably will be a corporate entity who is not owned separately, is owned by, let's say, Harry's Drugs, who says, yeah, this is happening, but not at this location. And Harry's Drugs will come in and say, maybe you should condition locations 1, 2, and 3, but 4, we've never had a problem and you can't show me that we have, and you shouldn't put conditions on location 4. I think that's going to be a topic of debate, and I look forward to that conversation because I think we'll get somewhere. We'll be able to make changes in some of the problems that we're seeing.
How much of that information will be made public?
The charging document would be made public, and all resulting motions would be made public. The hearing would be public, and the outcome would be public.
But not steps 1 and 2.
The inspection, we have interpreted it to be a matter of public record. We don't post them, we don't disclose them unless asked, but the Public Records Act doesn't protect them. And then the investigation of a complaint is completely confidential until charges are filed. And Senator Collmore, I had an answer for you on the retail chain question, how many of them are retail chains. We have 133 retail drug outlets and 105 of them are chains.
Okay, thank you.
If I may tag on, how many actual corporate entities does that represent?
Well, I think Mr. Duteau might be better. I know there's 5 within the association, but there's some outside of it. So Mr.
Yeah,
Duteau,
no, I know there are 5 drugstores, and there are all the food things and all those other ones.
Yeah, I'd say between 7 and 10.
Yeah.
Not all of them are members of our association.
Got it. Thanks.
You're welcome.
one should be careful not to say that Walmart is part of their association, as I did say one time. So Walmart is not part of their association.
Why does this surprise us?
Lauren, you also have to be careful with your examples because there is still a Harry's Pharmacy in Berlin.
Oh,
That's why I use Brian.
I honestly don't know if they're still in business. It used to be part of Harry's, which was a big, sort of what you'd call a department store in a certain kind of way.
They make
Oh, I
razors.
remember
went out of
Harry's.
business, but Harry's Pharmacy basically stayed in business as an independent pharmacy for a while. I haven't been by there in a long time, so I don't know if they're still there, but you just might want
As
to
a-
keep that in mind.
as a child, we would go to Harry's as like the big
Yeah.
event of the day, of the week.
Yeah, no, me too. Yeah.
I think they make razors now.
They do. Yes.
All right. So committee, where are we on this? came into it with a different understanding and am leaving with a different understanding. But I do think that I come down on the side with OPR on this one, because I think that if they do find that something is the result of not their own manager's policy or their own staff, but has come from someplace else, even if it's a misinterpretation of that policy, that OPR ought to be able to start looking at whether this happens in more than one location without having to open a separate investigation and a separate, I guess investigation is the right word, for each one, but to do it under the corporate headquarters of OPR, and to look at, and if in the initial stages, OPR finds out that it isn't as a result of an edict from above, then they would deal individually with the pharmacies that are not performing the way they should. If they find that it is as a result of an edict from above, then they would continue and figure out which of the pharmacies are impacted as a part of that corporation and which ones should have sanctions. Do I understand that?
Summarized that far better than I did, but yes, you did.
So I just, I don't see the need to have, if the same thing is happening as a result of a policy in 5 locations owned by the same corporation, I don't see the need for OPR to open 5 different investigations for that same issue.
And that's what we're trying to avoid, right? But
That is exactly what I'm trying to avoid.
that's why I would support this.
Committee?
Yes.
Yes, I would support it also.
Grudgingly.
Senator Rahm?
Yeah, I have no questions or concerns.
Yeah, because I was thinking that there were different standards being imposed on the chains, but that isn't the case here. So my misunderstanding led me down a different path to begin with.
And I will submit the written testimony. I'm going to modify it a little bit from what I sent to the House. My written testimony on this issue with the survey is under House GovOps. I'll obviously send it to all of you later this afternoon. My morning got away from me, so I apologize.
All right. And thank you, Mr. Duteau. I think that we were swayed by our Office of Professional Regulation, and hopefully all of those issues will be dealt with in the first steps of before it gets to a charging policy, or and can be worked out and continue the conversation between the pharmacies and corporations and OPR.
Well, thank you. And again, as I stated initially, we enjoy a very good relationship with OPR. It's a respectful and professional relationship. We'll continue to work very closely with them. Again, we still have concerns about this, but I think the best way to address concerns is continued and open dialogue. So I certainly appreciate the opportunity today, and thank you very much for your time.
Thank you. And you realize we do have an OPR bill every year.
Yes.
I want to reciprocate the gratitude for the conversation. It's been a good conversation that I've had with Mr. Duteau, and I'm very appreciative of it because it's a hard topic, and sometimes how the conversation proceeds when the topic is hard really boils down to who's engaged in the conversation. And Mr. Duteau has been excellent to work with. So I just want to say thank you.
It's mutual. Thank you.
And may I just say, as a committee member, Mike, it's very helpful to hear an outsider's view and confirmation of the great work of our OPR office, because we don't necessarily hear from an outside user this way. So thank you. That's it. It's interesting to hear.
Well, you're
Okay.
welcome. It's well deserved.
Thank you.
Thank you.
Okay. So I see we still have David Englander with us. And did you want to speak with us about death certificates?
I would love to speak with you about death certificates if you'll have me briefly.
We would love to have you.
Excellent. So my name is David Englander. I'm the Senior Policy and Legal Advisor for the Commissioner of Health. My testimony today, so we're talking about death certificates and who's eligible to sign them. And I just wanted to clear up some misconceptions that were shared with the committee the other day on this issue. So number one is that the Department of Health has not changed any policy or practice with regard to who is eligible. There was no shift in decision making. We've maintained throughout that Vermont law is actually very clear with regard to death certificates. I'm going to read briefly from 4999. 2, a licensed healthcare professional means a physician assistant, or advanced practice nurse. Director Hibbert mentioned this the other day. It's very, very clear in Vermont law that a naturopathic doctor has to be hold themselves out as a naturopathic doctor, an ND, a naturopathic physician. And so when it says physician, we presume the legislature was being precise in its language, and when it says an ND is something else, that those are two distinct categories. So that has been our position, not that the law would have to be changed to accommodate them, but rather the law is very clear. We presume that the General Assembly made a specific policy decision that we're carrying out. In addition, just so you know, a search of the death certificates on the database did not reveal any death certificates signed by naturopaths. So I just wanted to put that out there as a matter of clarity. I can stop there.
I do have some questions.
Please.
So we often write laws knowing what we know at the time. And so Mike, I have two questions. When was this statute put in place? Was it before we even licensed NDs in the state? Or so we didn't have NDs at the time, so there was no reason to accommodate them. And then regardless of what the law says, what is the harm, I guess, in having an ND sign? Because we can change the law. That's what we do. Mm-hmm. But is there a harm produced by allowing an ND to? I understand that the law is very clear.
Yeah.
But my question is, why would we maintain that law? When was it put into place, and what is the harm in changing it?
So it's a great question. So obviously in two different questions. Mm-hmm. So I don't, and perhaps Director Hibbert knows the answer. I don't know when NDs became a licensed professional in the state.
I think around 2006, around there.
So
Go try and find the answer.
I'm sorry.
I will investigate. I will be back with that answer.
It was after I got into the legislature and while I was still on health and welfare. So.
Wow, that's pretty late to have been licensing doctors.
NDs.
Oh, sorry, I'm sorry. Yes, it's hard. M and N.
Yeah, no, the reason I said when was we clearly said physicians, at the time, meaning medical doctors,
Right.
because that's what we had. My question was, we wouldn't have put NDs in there because we didn't have them at the time the law was crafted, is my guess. But anyway.
Although we assume, as somebody who interprets laws, since I'm not allowed to write them, we assume that the legislature has all that in mind. So when they instituted the ND, the naturopathic, when they established that as a licensed professional, that they would go through that was an intentional choice, that profession was not added to the death certificate.
I don't think it was. I can tell you then I was involved with the legislation at the time, and we did not go through all of the statutes to find out where it said physician.
No, and I'm simply speaking to a matter of interpretation that we wouldn't, at the Department of Health, we wouldn't make a value judgment.
Right, right.
We would simply look at the law and say, are they eligible, yes or no?
Right. So what is the harm?
Madam Chair, if I can just put in, it looks like naturopaths were, regulation of them started in 1995, and then their section of the statute was touched in 2001, in 1997, 2001, 2002, 2005, 2007, 2009, and 2009. Wow. So multiple modifications of the chapter. I'm just looking at one section of the law, but it does look like the regulation of them started in 1995.
Oh, okay. All right. Thank you.
And actually, I'm happy to dig into this. I actually think that this language was added the language from death certificates in the vital records chapter. I think that was added after that.
Okay. Well, so
but I'll find out for sure.
But let's figure out now, what is the harm?
Yes.
Why would could we change this without doing harm to the public?
Sure. So in speaking with the office of the chief medical examiner and a few other doctors, I'm not going to give you I don't have a clear answer, because I think all of us, or most of us, are at deficit to understand the naturopathic physician's training with regard to the processes of death. What I understand from talking to the office of the chief medical examiner is that even MDs with training, there is a significant complexity in determining death, and that the chief medical examiner frequently does trainings for physicians, for APRNs and for PAs, in order to assist them in determining the cause of death. That it is extremely complex. The office of chief medical examiner goes through every death certificate that comes through the office, 5,000 death certificates a year. And the office examines every single one to make determinations as to the precision of the finding, and spends many of their days in between autopsies contacting the licensed professionals and walking through their thinking and how they came to determination. So I think, put simply, I think it is sensible to put the burden on NDs to make a demonstration to the committee that they have the sufficient training and experience to make these determinations.
Mm-hmm. Yeah, I think that we've asked them to do that. And can I just ask you a question here? Is Beverly Hillstrom our chief ME?
No, it's Dr. Steve Shapiro.
Oh, apparently you don't read Archer Mayer and Joe Gunther.
Oh, I'm so sorry.
Sorry.
I don't really read fiction.
Well, you should.
No, I know. It's one of the many ways in which I'm a failure as a human being.
No, it's just an opportunity, David. It's an opportunity. I'm going to write that down.
Senator Collmore.
Thank you, Madam Chair. I guess I'll ask the question that's kind of 180 degrees from your question, Madam Chair. What's the problem we're trying to solve? Is it just because there's a group of people who would like to be able to do this, or do we have enough doctors to sign death certificates? I don't understand what the issue is that we're trying to solve.
Oh, I can tell you what the issue is. I believe is if my primary care person is a naturopath, and that's who I'm seeing, And I know plenty of people who only see naturopaths, and I die. Shouldn't that my primary care person be able to sign my death certificate? Instead of having to go find another doctor who doesn't even know me to sign the death certificate. That's the problem. It isn't that we don't have enough doctors to sign it. It's who's taking care of me, and do they have the training to be able to determine my cause of death for me and my family?
All right.
That's, yeah.
The law,
that's
as far as I'm able to understand it from Mr. Englander, says you got to call a doctor, an MD. That's the way it is.
Yeah.
But if your primary doctor is your ND naturopath, it doesn't make any sense to call it an MD. They've made a choice to not have an MD. They've made a choice to have a naturopath.
But when they made that choice, it was also obvious that they wouldn't be able to sign death certificates.
I don't think it was obvious. I think that if I'm a patient, I wouldn't have any reason to know that if I die, my doc can't sign I consider, yes, Senator Rahm.
How many other states let naturopaths sign death certificates?
Maybe Lauren knows. We asked.
I don't know. I haven't looked into that since the last hearing. I could try to find that out, but I thought that the Association for Naturopaths was going to bring that information.
I think Josh was going to get back to us with that.
Yes, and I think that Mr. Englander is right, that what we need to do is the responsibility here is on the naturopaths to show that they do have the training to be able to determine cause of death. And if that's true, then then we can change the law. If that's not true, then we probably leave the law the way it is right now. But if they do have the training to determine cause of death, or close enough that if the chief medical examiner goes through all the death certificates anyway, and even questions some that are signed by MDs, then maybe they have to have that as part of their ongoing professional development training, is whatever training the chief medical examiner gives around determining cause of death. I don't know, but I think you're right. We need to ask them to show us that they have the training.
Yep.
I just want to, I don't know if David or anyone else has a thought related to this, but I tend to have the same line of inquiry that Senator Collmore does. And maybe it's because I sat across from Vince Aluzzi on a lot of conference committees about burials and death, where he wanted to just have cremation without the chief medical officer pronouncing someone dead. And so, have a lot of experience thinking about this, but, it just seems that signing a death certificate is not just about the individual and their family. In fact, that's just a small part of what a death certificate means in society. So, I just feel like we're focusing a lot on what the person's wishes would be, but a death certificate has a lot to do with Department of Health records, trends, patterns, foul play, crime, etc. So I just don't hear us having enough of that conversation.
So
I do agree with you, but I think that if they've had as much training as a medical doctor, then they should have the right to do it. And I will disclose here that I was the administrative director of an integrated holistic health clinic. And we employed naturopaths, and we had 23 different modalities. And those naturopaths were, in my opinion, as well versed in determining infectious diseases and cause of death. And so they would not, having them sign it would not disrupt the research that needs to be done by the Department of Health. But that's just my personal opinion. But we do need to have them
and
weigh
we
in.
asked Josh to bring this information back. So I think we should wait and have this conversation when we get the
Yep.
the
Is Josh head of like the naturopaths society? Is he like empowered by the other naturopaths to speak for the naturopaths? Okay.
And we
And
can also, if you have naturopaths that you know, and have any, if you have constituents who are naturopaths, it would be great for them to weigh in. I mean,
Well, I think that the important thing is here if they've been trained or not.
right.
Just if they haven't been trained, it doesn't make any difference if all 55 of them come in and say, yes, I ought to be able to do this, if they haven't been trained. If they have been trained, then even if 30 of them come in and say, I never want to sign a death certificate, that shouldn't sway us either. It should be whether they have the training and are capable of determining the cause of death.
Right. I found his testimony very informal and not sort of like I've surveyed all my members and here's what's happening. So that concerned me. And I really, when we talk about what other states are doing, et cetera, I'd rather rely on someone else for information. That's all I'm saying. If a constituent is listening to me right now, wants to reach out, great. But I found it too informal to be reliable.
Well, that's, we'll see what he brings in when he comes with the training.
And I think we sometimes have to be careful not to just to separate the message from the messenger.
Yeah.
And
Lauren.
Senator Ram, I will look into the issue before next Tuesday, and I'll do my best to find the answer. I don't have the same network that he has in terms of other associations, but I can do some research on my own, and I'll try to find the answer, and perhaps David could talk to other departments of health as well.
And maybe the chief medical examiner, if he is it a he or a she?
Shapiro.
Is the he, Stephen Shapiro.
He has information about what kind of training he feels would be necessary to have to determine it. Then we can weigh that against what training there is.
I'm sorry.
No, and he may have experience with naturopaths and be okay with, think this is a good idea.
Well, he wouldn't, because he said there have been none signed by naturopaths.
Oh, he's already weighed in. I hadn't.
No, yes. Oh, yes.
The
David testified to that.
Oh, that was, got it.
So it would be incredibly useful for the OCME to be able to look at the training. If the NDs can provide a curriculum, it'd be incredibly useful for us to be able to look at it and examine it and then provide testimony on the substance of it.
Yep, and that's what we will do. So we will not do anything with this bill at all until we get that information and we get the fee information for the MMAs. And then we have the APRN request to do a cataloging of all the places where physician is used. I know that Betsy Ann Rask started that project a number of years ago. I have no idea what happened to it. But I guess I'll check with Ameren, maybe if you want to check with Ledge Counsel and just see where that went, because I know she had started it at the time to look at different places where it might say physician, where it really should say physician and medical physician, ND, or APRN.
Yes, I can look at that.
Okay, thanks. Are there other issues around the OPR bill that we need to resolve? So it's just really the death certificates, the potential cataloging, and the MMA fees. Senator Clarkson?
If the general contractors bill, if the contractors bill gets over H157, I think it is, would we consider consolidating it and putting it onto the OPR bill? And would OPR want us to do that? I'm just curious. given it's an OPR registration. Remember, it's this light touch, our favorite subject. I'm just curious. I mean,
So I think there's two questions there. The first one, I think, is entirely up to your committee. And the second one, I believe, Senator Clarkson, you were addressing to me. So the Office of Professional Regulation strongly supports the home contractor bill. I don't think, even though we're not in the building, I'm sure that you all have felt the ripple effects of it going through the House. So, or have heard rumor of how it's gone through the House. So I would almost prefer that it stay its own bill and stand on its own merits than drag. I don't think that it should drag down the OPR bill. I think it's a good bill. It's a consumer protection bill. It is a light touch bill. If this committee gets that bill, you'll hear me testify about my support of this bill. And if you don't and you want to talk to me about it anytime, I'm happy to talk about it. The office supports H157. That being said, it has been a very interesting legislative path heretofore. I'm excited. I'm excited for where it goes next, but I wouldn't want it to affect the other issues that I'm also advocating for. Okay. And that's the best way that I can surmise my position.
I agree with you, because I think that bill itself is going to be much more controversial than anything in the OPR bill.
Yeah, and they've done good work in the House, and they've gotten it through. Third reading happened yesterday, so it's coming our way, and it's probably coming to this committee. And at the Senate Economic Development will probably ask for to weigh in on the licensure and contract pieces. But other than that, my guess is it's coming here. I
look forward to talking about it with you all.
Good. And I look forward to having it on the floor again.
I don't look forward to it.
I listen, that was one of that. I reported that bill. I took it. I managed to get it through. We got it to the House. Where they're finally dealing with it now. And now it's back to us.
I think it passed.
It did pass.
It did pass.
Yep, they passed third reading yesterday.
Yeah.
Yeah, we had Chip Troiano, who represented, who was the reporter Chip came into Senate Economic Development this morning.
Oh. Okay, well, I just feel sorry for the poor college kid who's going to have to spend $250 on a registration fee because he puts new steps on my back porch.
Honey, so it no longer is it that reasonable. The house
$3,500.
Yeah, they've gone. It's way over. It's very. Yes, but we can have the opportunity to make it better.
Did you say 3,500?
Yes.
Yes. If you do anything over $3,500, you have to have a written contract and you have to have your $250 registration.
No, it's now $3,500. It's $3,500 to register, and it's $3,500 threshold.
No,
it's $75 for an individual and $250 for a business, and $3,500 as the threshold to register.
So we misunderstood that this morning. This morning, I thought that there was another $3,500 that they made it tit for tat. Okay, great. That's good. That's great. It keeps, because the registration fee is not that much. It's just the job, and they've raised that, Jeanette, to $3,500. So you'll be happy with that.
No, $3,500. Have you tried to do any carpentry lately?
Yes, I know but it also, as we know, is one of the top consumer protection issues in the state. More people.
Okay, we've gotten a little bit off topic here. We'll deal with that if it comes to us.
It's a preamble.
And I look forward to the conversation.
I'm sure we all do.
Hey, it could be worse.
Okay, well, thank you. I think that we have, let's see, I have so many Oh, do we have Becky coming in on H330? Thank you, David, for joining us, and thank you, Lauren.
Did you want to hear from me on MA,
Oh, do
MMA
you have the
fees?
fees?
Yes.
Oh, you have? Oh, okay. I didn't
Yes.
know that you had settled on them.
Yes,
Okay.
we did.
Sure.
And I did send some proposed language to Amarin. I don't know if that's made it onto the website, Amarin. Okay, let me find it. Essentially, the fees would be the same. The piece that is changing is the gate tax from the event. And the rationale for changing it is we have very small venues in Vermont. And so to take 5% of the gross receipts from an event might dissuade people from coming in and holding events because the seat numbers are smaller than, say, New Jersey. So I'm just not picking on New Jersey, but New Jersey has big venues and we have small ones. So the language is in the new section, and I think that is draft 1.5. Is that, I'm sorry, Amarin, is that correct? Is it draft 1.5?
It is draft 1.5. It's on page 17 in section 6039.
That's our amendment, right?
Yes.
Yes. So the new language starts to contemplate the idea of net receipts. So what will happen is we will take then a percentage of the net receipts, a 5% percentage, 5% of the net receipts. So we'll take the gross, which is receipts from tickets, admissions, fees, and sponsorships after all the costs from the event and any other state or federal taxes thereon have been paid. And we did talk about that with Mr. Thompson, and he is thinks this is a good solution, and so does OPR.
Oh, great. Any questions about that? That sounds like a good solution. Thank you.
Oh, you're welcome. I can't actually take very much credit for it. Lauren Lehman and Rex Thompson did that. So.
Okay. Well, we're lucky to have two Laurens.
Yes.
Okay, any other questions for Lauren?
The other piece that Amarin and I have been talking about is the effective dates of this bill. I think I mentioned on Tuesday that I do need the well drillers to be effective on passage, and there's a couple of sections that mention well drillers. The other piece is the uniform endorsement.
I'm sorry. Before we leave the tax section and the fee section, I have a question. I apologize, Lauren. I just was reading this, and the promoter pays the tax to the tax department. There's a tax on every feed, every piece. Why would they pay it to the Department of Professional Regulation?
I think it's a great question. It's why I don't love the word tax. It's an event fee. It's not a tax like one would pay to the tax department. But we did use the word tax because that is the word that's used in other states. And it's to support the regulatory program, to do the inspections, to manage any unprofessional conduct complaints.
I get that, and I think that's great. But there is a tax. We tax every event, so there is a Vermont state tax on every ticket sold to a theater, to a film, to
That's
a
right.
MA. So I hate to be a stickler here, but the tax is paid to the tax department. Whatever they pay to you needs to be called something else, or should be called something else, in my humble opinion. Because
I think that they use that because other states use it and because it's used in the boxing statutes that currently exist
okay,
in
so
Vermont.
how do we differentiate the sales tax, which is on every ticket?
Because it's a net receipts tax.
This is a net receipts. How did I miss that?
This tax is going to be 5% of essentially of the profit. 5% of what's left after expenses are paid. So it's 5% of the net.
Okay, so this is after they've paid the trust tax of the
Everything.
Right, everything.
I apologize. I guess
And the way that OPR will operationalize this is we'll create a form for the promoter to fill out and calculate what the gross receipts were, how much they paid to the state, how much they had to pay for the physician who had to attend the fight, how much they had to pay the fighters, all the costs of the fight, the location, and then that will dramatically reduce the total that we're calculating the 5% on. And that was the accommodation that we made with Mr. Thompson.
Senator Rahm, you had a question?
Yeah, I mean, just while we have Lauren, and this has been raised in this committee, but it may show up in H-159, which is in Senate Economic Development. That bill has a whole section on supporting BIPOC businesses and entrepreneurs. So it sort of calls for the creation of more of that system for identifying demographic information for business registration. And I personally feel like that's a good place to put in OPR as well, because for a lot of businesses, they're a sole proprietor. They're just a licensed person. And I think it's time we start respectfully collecting that demographic information. So that'll probably show up in Senate Economic Development as a discussion.
I look forward to the conversation, Senator Rahm. I heard you not last time I came before this committee, but maybe the time before on that topic. I've thought a lot about it. I've thought about how we could operationalize it. I would want to make sure that it was, and I can talk about this in Senate Development or wherever it's appropriate, but I want to make sure that we collect the data as the legislature recommends, but that it's not tied to a specific licensure decision. Maybe it could be something done post licensure decision or separate from the application. I just want to be very careful that I don't introduce any opportunity outside of what already exists in what we all know to just be in the world of bias on the behalf of my team. And I don't think that my team would do that, but I just want to be careful. And I want to talk to some other licensing agencies to see how they handle this issue, because I want to be very conscious of what we do with the data and how we use it, and what the expectations are from the legislature and from the Secretary of State on what we do with the data, who we release it to, how we analyze it. All of those questions are big for me, because I don't want to collect the data and then do nothing with it, or create the impression for anyone that I am doing something with it, which I think is the other piece that I just want to be careful of. So I look forward to the conversation. I think there's some really exciting opportunities there. Whether it's in this committee or in Senate Development, I look forward to it.
It is an interesting question about how you collect that, because I know with public housing, for example, when you fill out an application for public housing, it asks you for race and ethnicity, but it very clearly says this is optional because of the fear of discrimination against if you fill it out. So it's interesting how you collect it without there being a perception that you're using it in a negative manner. So
and some articulation of why
right.
is the other piece to the person. If someone is asking me my race and my sexual orientation and my marriage status, I want to know why they're asking me those things, because those things matter to me personally when I disclose it. And I have been treated differently on the basis of my answers to those questions. So I don't want to willy-nilly give that information to everybody. So, but I'm very fortunate in that the way that makes me different is not noticeable by my name.
is not noticeable by where I went to college. You know, if I went to a historically Black college, for instance, one could make an assumption about who I was, or if I had a more, a name that wasn't Lauren, that would be, you know, someone could make an assumption about who my race was. So those are just questions that for me personally, I think about, but also I would take a lot of responsibility in gathering the data. So I just want to make sure that I'm doing it in an appropriate way and in a respectful way.
And we need to make sure that in every department and every agency, if we could collect that information, that this is a little bit off that topic, but we were having a conversation the other night and something came up about ethnic food. And my friend said, well, what is ethnic food anyway? If you live in Saudi Arabia, is mashed potatoes an ethnic food? I mean, what do we consider an ethnic food here? Because lutefisk and lefse, are they ethnic foods?
Yes. And you know, that's the joke, is that ethnic food here is not ethnic food where it was originally created. And yet anything that has a tie to some ethnicity is considered ethnic food, which is ridiculous. It's all American food.
I've never heard of lutefisk and lefse considered ethnic food. Most people just consider it not food.
Well, there's that.
Well, I think there's a lot of important conversations to be had about whiteness being the definition of standard and everything else being outside of that. And
right, exactly.
I think it's a really important conversation. And I feel the same way with male being standard and heteronormativity being standard. And I think it's really important conversation. So I look forward to the conversation and all the intricacies that are involved. And also operationally, I did ask my team how they would do it. I think there's some opportunities with SurveyMonkey or our software system to do the collection of that data in a voluntary way or in an involuntary way, depending on the direction of the legislature.
So can I just ask on this conversation before we switch here, you mentioned H-159. I'm not sure what that is, but is there a role for the state to somehow come up with a standard way of collecting data and how it's going to be used and stuff, so that it doesn't depend on each agency and each department? Is that
a good question for me?
Well, for anybody. I just am throwing that out because I think it's we have many agencies and many departments, and we're looking at how do you collect data and why do you collect it, and is there a standard way and a standard way of using it and releasing it and aggregating it? And
it's a good question for Sue Zeller, and it does raise the question that Keisha's asked, which is we don't have a planning department. Would sort of belong in planning or in HR or in Sue Zeller's. I mean, you know, we don't have an office of the Vermont citizen, which would go. It's a good question. Is where does it belong? And it or maybe it belongs with Tanya as part of our archive of who we are.
That's an interesting question. We should have that conversation.
It would be great to have one place to go get it. I mean, where do you go now when you want to see the Castleton poll, all the data that's collected about Vermonters? And it's, once we have a reliable source, it would be great to funnel it all there so we could go one place to get it, for just like we go to JFO to get a fiscal note on something. We could go somewhere to get a demographic note or a.
Yeah, I just was wondering, because we have a bill in judiciary right now that's setting up a whole bureau to just collect racial data in the criminal justice system. And I'm thinking, why would we separate
we
collecting it there from
all on every
Anyway,
I do think there's the potential to be very siloed, which goes to my question about what do I do with the demographic information once I collect it, and what are people expecting my office to do with it, which is probably even more important. It certainly could be a topic of part of the annual report that we file every year. but what further responsibilities would we have? And I feel fairly confident that I would do what was expected, but I would want it to be put into the statute so that the next director would do that as well, and so that it was clear what the legislature was intending.
Speaking of putting it into the statutes, so the next time we do OPR, we will look at the death certificate question and the potential language from the CSG.
Oh, great.
Okay,
Thank you so much for your time.
thank you.
It's always a pleasure.
And I see Becky is here with us. Thank you, Amran. Hi, Becky. So you were going to give us some information about the contracting procedure for with LexisNexis about our state publications and kind of what the process is and when the next time comes up.
Sure. Yeah, I didn't know exactly the information you needed, but I'm happy to generally tell you the process and answer any questions. So Becky Wasserman, Legislative Counsel. So we have, Leg Counsel is responsible for the contracting with Lexis. We do have a contract in place that the most recent one, the underlying contract was signed in November 2016, and we had some extensions to that to just renew it for a couple of years. And so as of now, the latest extension brings us to December 31st of this year. So that is when the contract is up. So under the contract right now, we don't have any more extensions available. They're usually done in 1-year extensions, and there's a certain number that you can do until you typically do another contract, although we could also just amend the contract to say we could do more. But that is, I guess that's the state of where we are in terms of when the contract is up for renegotiation. And typically we try to do that a little bit ahead of time, like, a month or two ahead of time, so we're not kind of running up on the deadline.
And the contracts, remind me, good for how many years you just said? It's good.
So the underlying contract was, just double check here. It was signed in November of 2016. And I think it was I believe it was a 2-year contract, but I'm just double checking that. And then we had 2 1-year extensions on top of that.
So are you the chief negotiator with the contract on behalf of Leg Counsel?
Typically I do negotiate all of the contracts for Leg Counsel. For the Lexis ones, there are other attorneys involved just because it because it's dealing with the statutory revision process, which Jen Carby is the person that leads that. So she's also been involved, and I believe in the past Michael Chernick was more involved in the contract negotiation process as well. But I do review all the contracts.
So I guess the question is, you saw the amendment that Tucker put onto there. Is that a reasonable amendment?
In terms of requiring that the contract and the statute line up. Yeah, I think that it would be helpful to make sure that whatever amendments are made to statute allow for it to be flexible to what the contract allows.
And that does it.
Yeah, so I think one of the issues would be is if you amend the statute to allow for something that is not in the underlying contract, then we would have an issue with how to deal with that.
Mhm.
And the statute, as you know, is not easy to change. So, and the contract is something that does get renegotiated fairly periodically. So I think that there should be some consistency to what is authorized under statute. I guess I would say I don't think it's necessary that the statute is very prescriptive over you know, the numbers of copies, or as long as it's authorizing that it can be what that it can be distributed to different parties. That, you know, the contract goes into much more detail about the
Mhm.
numbers of copies provided and the price per copy and those sorts of things. And I think that's probably more appropriate for the contract than it is for statute.
And I think that this statute does that, right? The way he's written it, it says that what he added there to the House version was that they could dispose of other publications within the terms of the contract.
Yeah, that was my understanding of the change that was made,
So-
just to keep it consistent.
Yeah.
And that being said, I think that might change practice, but it would be lining up the statute and the contract.
Which is probably a good thing.
Yeah.
That would be a good thing. Yes.
So Becky, forgive me if I totally missed this, because I apologize. I was a little preoccupied when you began. But the 1-year extensions, are we ready to sign a new contract that's a little longer than a 1-year extension every year?
Yeah, so the 1-year extension is up December 31st of 2021. So at that point, we would need to sign a new contract.
And we would hope it wouldn't just be an extension, but a contract that was for several years, so you don't have to keep duplicating your effort. It's a lot of work to do those.
Yeah, I think typically, you know, what's in them is pretty similar, but you know, it just has to, sometimes there's minor amendments that are made when we renew it. So, but I think it's typical that we have contracts that have, you know, 1-year renewals, just so that we don't have to do it every single year.
Yeah, I mean, it's a pain to have to do every year.
Yeah.
Okay, are there any other questions about that? And
Madam Chair,
yes,
I just wanted to note that I invited Tom McMurrow at the last minute, so he is coming in a little bit late to the conversation, but
Yep,
I
thank
appreciate
you.
him
Yep.
taking the time.
Thank you. So what we've heard, Tom, is that there will be a new contract negotiated, or this contract ends December 31st. And so before then, there will be a new contract negotiated. And that the language that Tucker suggested adding around disposing of other state publications, the language that he added within the terms of the contract line up then the statutes in the contract. And so that I think what we're doing is deciding whether we should do that or not, leave that language in. And Becky has suggested that we do.
And I just found the amendment. So it says that the sale would have to be permitted by the publishing contract.
Yeah,
Right. So if I may.
Yep. And
Thank
we
you.
need to be very careful here that we're not talking about the contract itself.
Right. I just want to be clear that this applies to the Vermont statutes annotated only.
Becky?
You're muted, Becky.
The amendment language
The amendment language would apply to any, right. So yeah, this does hit the contract idea, but as the contracts currently stand, the only conflict would be with the contract with LexisNexis for printing of the Vermont statutes annotated and not any of the other publications that are mentioned.
So if it wasn't, if there's only restrictions in the contract around that, that's the only thing it would apply to. But if there were, I would think that if in the contract there, the new negotiated contract, there's some other restrictions, then that would apply to that also. Is that?
So I, not having drafted this bill, but I'm just looking at the section that it's amending, which in the underlying bill is 22 VSA 611, and that is specifically talking about the Vermont statutes annotated. So it's
Okay.
It's specifically talking about the librarian distributing copies of the VSA and then and any cumulative pocket part supplements, and that is the subject of what the publishing contract is about. So this would, I think this seems to line up with what we're talking about here of just making sure that the sale of those lines up with the publishing contract. So I guess I don't know if there's any other, what else you're looking to sell, but this this section is specifically talking about the VSA.
Tom?
Yeah, so effectively the sale of these is barred by the contract.
I don't know if it is or not.
So I think what I'm comfortable talking about is just that what the amendment is doing is allowing for whatever is in the contract to be the same as what is permitted under statute.
So if the contract would bar the sale of it, then it would be barred. If this contract says you can sell them for $2 a piece, that's what you can do. If the contract is silent on it, then I mean,
right. And obviously we are, it's something that is negotiated, you know, every few years. So, I mean, I don't know that it's always going to be the same. What's in the contract is always going to be the same. So I think this is just an attempt to make sure that what is authorized under statute is the same as what is authorized in the contract.
Any other questions about that or concerns?
Well, I have a concern. This is the state librarian. Hello, sorry for being late.
Yeah.
My 10th Zoom meeting, right, Tom? So, so I'm still alive. I think one of my concerns, I think one of my concerns for our department is, one, we don't ever have a connection to the contract. And I would love to see that grow over time, because we are what I would say are known as downstream processing. Upstream does not always know what is happening downstream. And the reason why this has a huge impact is because I will probably have to discuss this with our agency secretary, with the commissioner, Jennifer Fitch of BGS. Here's why. We are charged for transportation of those items back out to state government after they come to our department for distribution. There is a charge that comes to us, and that would come out of our budget. And if there is no incoming, not saying this provided any funding near enough to do that, I will have to discuss how the department will maintain finances of distributing these every time they come in, because we are the distribution center and BGS is a transportation that does so.
I would recommend that you be part of, you or BGS or somebody downstream, be part of the negotiating process.
Hear, hear.
And maybe
I'm happy to coordinate with that. I guess I will say that the contract does contemplate that sort of shipping distribution rate. So we can discuss that further, but I do think that is a really good point, that the parties that are involved should all know what is permitted.
Well, and the parties involved should have input, I think.
Yeah. So we will trust that you will do that, but I think that what we will do is we as a committee will write one of our famous letters to, and I guess we would address it to Jen and Becky and is it Jennifer Fitch? Yeah.
She's the commissioner, the new commissioner of BGS.
Right. To just make sure that all the parties are involved in the, because we don't need to put that in statute.
But is she the one currently negotiating? I thought Becky was negotiating the contract.
Yeah, as I said, that we will send a copy to her so that she can see that we're asking that either she or Jason or somebody be involved in the negotiations. Yeah.
Great. I think that's terrific.
Yeah. Okay. So are we ready to vote on this bill? Anybody?
Do we want to vote on it before we have answers to some of the, I guess we won't have because the contract negotiation isn't until December.
We won't have answers to anything because, and we're not really concerned about the contract. What we're concerned about is that the statute and the contract.
Very budget.
Well, we can't control that.
I know, but we can advocate, which we're doing.
We can advocate that they be involved in it. And I think Becky has said that there is some language around shipping costs and stuff. So I think that we can't go any deeper into the contract. We have no business doing that. What we have business doing is making sure that the rest of the bill passes and that we say any sale of those has to be within the terms of the contract. I said that different. Becky said it much better because she actually read the amendment. Am I right about that?
I think so. I think you are. Becky's smiling. So
that's my understanding of the amendment.
Yeah.
I think the intent behind it was just to make sure that whatever is authorized under statute is in line with what is permitted under the contract.
Yep.
And seeing as the contract is a somewhat moving target, it's better to make it a little more flexible so that we don't come up against a situation where they are perhaps in conflict.
Mm-hmm. Okay. Anybody care to move this bill?
I'd be glad to, Madam Chair, but I don't know what the number is and it's not on our agenda.
It's 337.
I'm sorry?
337, H337.
Yeah, 337. It's on today's agenda. It's 337.
I would move that the committee vote out H337 with no amendments.
No. We first need to amend it with, and I don't have in front of me the number, but I would guess it's 1.1. That was the only amendment.
We should have it here.
Yeah, Tucker did send it to us.
Under Tucker's name, and it's, oh no, I'm wrong.
Allison, if you want to make the motion, I still don't see it on the agenda.
Oh, it's on the agenda under today.
Really?
At least I was seeing it on the agenda under today.
Yeah, it is. It was set for 3 o'clock.
3 o'clock, it says H337, but what I don't see in our documents is I don't see Tucker's.
Well, it wouldn't be in our documents for today. It was some time ago.
Oh,
I think it might have been.
It was March 31st.
31st. March 31st.
I will post that
at 12 o'clock.
I will post that for today. It will just take a couple of minutes to come up.
And it is
1.1.
1.1. That's what I thought. Okay. So Brian, Senator Collmore, do you still want to make that?
Yes, Madam Chair, I'm writing it down. I move that the committee vote out the amendment containing draft 1.1 on Bill H337.
Good, thank you.
Okay, I'll call the roll. Senator Clarkson,
Yes.
Senator Collmore,
Yes.
Senator Polina,
Yes.
myself, Senator Rom, yes. Senator White,
Yes.
and the committee has amended H337 with draft 1.1 by a vote of 500.
Yes.
Now
Senator Collmore.
I further move that the committee vote out H337 as amended.
Okay.
Okay. Senator Clarkson,
Yes.
Senator Collmore,
Yes.
Senator Polina,
Yes.
myself, Senator Rom, yes. Senator White,
Yes.
and the committee passes the bill 500.
Would anybody like to report this bill? Anybody have an interest in publications in the libraries and our
We all-
publications?
We
Huh?
all have interest in libraries and publications.
But would anybody like to report the bill? I'm not seeing anybody jump around up and down about it.
Well, if I hadn't just agreed to do 151 yesterday, I guess I'm happy to do this one as well. But I mean, I'm happy if somebody else wants to do it too.
I'm happy to do it if no one else wants to, so.
Okay, well, why don't you do it? We'll be doing things close to each other.
Okay.
I'll do 151 and you're doing 337.
Okay.
What?
So,
Unless, are you thinking down the line, who, are you wanting to do OPR?
no, I don't, I'm perfectly happy to let anybody do any bills. I think that if we get to the point of doing the Agency of Public Safety, I probably will do that.
Yeah.
But if we get to that point, but I'm perfectly happy to let anybody report any bill they want to.
Thank you for that, Madam Chair.
So, okay. So this should be on the agenda, Jason and Tom. It should be on the agenda for,
It'll be on notice tomorrow, if you get it up there.
if we get it up there, it could be on notice tomorrow. It could be either Tuesday or Wednesday then that we do it.
I'll be on Tuesday, I think, because I think 151 will be on tomorrow.
Thank you.
The department thanks you. The state
Well,
library thanks you, and my staff thanks you.
Thank you.
Thank you.
Okay, committee.
And thank you, gentlemen, for joining us at the last minute.
Happy
Yes,
to.
and thank Becky for coming in and talking with us. So I believe at 3:30, we had scheduled some time for people to come to talk to us about our nominees. No one has contacted me. I don't know if anybody has contacted any of the rest of you
No,
or Gail.
No.
No. So what I would suggest is that we take a break,
good.
that we come back, and then we could ourselves then, knowing that if no one shows up, that we can take a vote on the 4 nominees and then forward them to the floor.
Sounds good.
Sounds good. How many minutes? 10 minutes? Till
Let's
3?
see. Yeah, let's do 15 minutes.
About 3:45.
3:40.
Or 3:40. How about 3:40?
Yeah, 3-4. Let's do, so we can have time to talk about, because there are 4 people and I'd like to get them just done with.
We're live.
So let's look at the nominees that we had. We had 4 of them coming from the governor's office: Suzanne Young, Adam Gresham, Beth Festigi, and John Quinn. So we need to decide if we're going to forward those to the Senate. So would somebody like to start? Who was reporting? Suzanne, would you like to? Okay, Brian?
Yes, Madam Chair, and I did get a very short, which I appreciate, resume. It'll take me about 35 seconds to read it. And I would move that we vote in favor of her confirmation.
Okay. Yeah, she had some really interesting things to say, I think, about how the COVID has has made people work together in a much better way.
Yep.
And the strength of what she saw as the state workforce. I thought that was okay.
Yeah, I would just add, I mean, Suzanne knows government better than most people. She's been in a lot of roles and done
Yeah.
a lot, and that's really helpful right now.
And under a lot of governors.
Yes, exactly.
Mhm. So I guess we take a roll call on these.
Definitely on the secretary.
Yeah. Let's do it on all of them just to so that we have that.
Gail, do you feel, I don't know if it's the same form, I imagine, so we'll just.
I would,
Mhm.
I'd use the same form.
I don't know if there is a form. Okay.
We could just say like confirmation or something. Well, it
Yeah.
won't have a bill number, right? It just,
No, there won't be a bill number.
okay. Was that moved? Did that just get moved?
Yeah.
Yeah.
Okay. Okay, Senator Clarkson,
Yes.
Senator Collmore,
Yes.
Senator Polina,
Yes.
myself, Senator Rahm, yes, Senator White.
Yes.
Okay, and we voted to advance Suzanne Young for confirmation by the Senate on a vote of 5-0.
Yeah, that's a perfect way to put it. Yeah. Okay, who did Beth?
I did.
Oh yeah, okay. Did you have
I
any?
also got a very short bio from her, a paragraph, which was more than enough, but she seems fine to me. I would move that we confirm her.
Yeah, I think she also made some really good comments about the state workforce and how resilient they were and how much they stepped up to the plate and her desire to go forward with the classification system.
Right.
Did you know that, they asked for $125,000 to do the next step? The House took it out.
Mm.
What? How do they expect they're going to finance it?
I don't know, but they took it out. So I wrote a note to Jane and Adam this morning and said that our committee had heard the presentation and I thought we were in favor of moving forward with the reclassification system. It's so out of date that, anyway, Jane intends to put it back, just so you know.
What would the money be used for?
It's the next, I don't remember now exactly what the next steps were, but they have this whole timeline of what the next steps are in terms of the reclassification system.
Right.
And I don't remember the next steps.
Okay.
We do have it. It's on probably on our website on those
Sure.
slides that were given to us. So,
Okay.
but I don't think you have to talk about that because Jane will in the
No.
budget.
No.
Just talk about how they're moving forward with it. if you
Right.
want.
Right. Reclassifying.
Mhm.
We have like, how many thousands do we have right now?
1,800 classes.
Pretty
And
amazing. It's almost like it's like one for every 2 people.
They're hoping to get it down to 1,100 or 1,200. It's not like they're hoping to get it down to 3.
I know, and they could probably even get it down below that. New Jersey, I think they said, has something like 80,000 employees and they have 700 classifications or something like that. Anyway, okay. So do you want to call the roll on Beth Vestigi?
Sure. Senator Clarkson,
Yes.
Senator Collmore,
Yes.
Senator Polina,
Yes.
myself, Senator Ram, yes. Senator White.
Yes.
And we are voting to advance Beth Vestigi to the full Senate for confirmation.
And before we move to Adam and then John Quinn, Keisha, you haven't been here when we've done these before, but usually the way they happen is we send them up. They appear on the end of the last page of the calendar.
Okay.
And the ones that are underlined have to be reported on. And as far as I know, we haven't gotten any non-underlined people yet at all. I mean, that's like boards and commissions and stuff. And then
Okay.
usually what happens is on a Friday, I will make arrangements with the pro tem and just ask for us to take up the confirmations. So you should be ready.
By next Friday.
By next Friday. Got
And
it.
it may not happen next Friday. It
Okay.
depends entirely on the schedule and how busy we are, whether they take them up or not.
Are we like working faster than other? Are we going to start seeing a lot of these, or are we moving more quickly than other?
I have no idea because I don't know if other committees have received.
Well, you know about judiciary. Have you done any of your appointments in judiciary?
I don't know if we've even gotten any. Who would we get?
Well, check with Peggy. Peggy will tell you if you've gotten some. You just may
I
not.
can interject. All of the committees have gotten their appointees. I don't know if they've voted on them, but they have gotten them.
Yeah,
I don't-
we dealt with ours in Senate Economic Development, and we need to. So
I don't think judiciary gets any because the judiciary is a separate branch. We confirm judges when they're first appointed.
Well, you might check with Peg anyway, just to make sure. Do you want me to? Are we ready to chat about Adam? Or are we still?
Yeah,
voting?
just reminding people to be ready potentially on Friday
Right. Next.
or any Friday thereafter.
Right.
Okay.
Keep it in your desk drawer, as they.
I know.
Oh Lordy. Okay, Adam. Adam's enthusiasm for his job it always is palpable, and I appreciate, because I also appreciate the fact that he is a legislator and he can appreciate what the process we have to go through to do the budget, and he now is appreciating his process. And I think that's so valuable, actually, for the legislature to have a former legislator in that capacity. I also appreciate that, one of his biggest, he's met in talking about, we talked about a lot of things, but retention was his biggest problem last time. And now all his hires have stuck and stayed. I think he's solved a couple of his problems, the challenges that he had before. I think he seems to be doing a terrific job. We don't have any way of going out into the world and getting outside opinions about these people, but my impression is that he really enjoys his job. He seems to be growing in his job. And he seems to be doing a good job, and he keeps learning on the job. And I love the fact that he shares that he's learning things all the time. And he talked about the lessons learned, that there's so many different ways to achieve the same goals and the same results, and that we need to sort of begin to look at state government and some of the things we've just assumed and taken for granted, and have to relook at them. I appreciate his honesty in talking about human services is the biggest challenge in his budget as he builds the budget. I'm impressed by Adam. I think Adam continues to do a good job and serves Vermont well. And I think he enjoys serving Vermont in this new capacity. And so I would support our advancing his confirmation.
Okay. Anybody else have any comments?
No, I like him a lot.
Yeah. And his enjoyment of the mix of finance and public policy is, well, I think that's great. That he enjoys it.
Just to
Okay.
give Adam a hard time, I've never personally experienced his excitement as palpable. I feel like he's so understated.
Oh,
But
really?
I do love Adam as someone who served on committee with him as well.
Didn't you experience that a little bit from him in his testimony the other day, last week?
I feel like he has an interesting way of sort of expressing his passion for things. I feel like it's kind of muted, but it's clear. It's clear. He's so hardworking. I'm just giving him a hard time because I can, but I've never thought of him as having palpable excitement.
Palpable is in the eye of the beholder.
I had to sit across from him for 6 years.
I know.
6 years? Yeah, 4 or 6 years. And for me, that was palpable compared to the other times the patient I've seen him.
We love Adam. He's good at what he does.
Okay.
And I think he's serving Vermont nicely. So I really am proud of him.
You want to move that we confirm him?
I did.
Oh, you did. I didn't hear that. Sorry.
I'll say it again. I move that we confirm Adam Gresham to the job of Director of Finance for the state of Vermont.
Okay.
Okay. Senator Clarkson,
Yes.
Senator Collmore,
Yes.
Senator Polina,
Yes.
myself, Senator Rom, yes, Senator White,
Yes.
and we are advancing Adam Gresham for confirmation by the Senate on a vote of 5-0-0.
Okay. John Quinn.
Yeah, so I feel like, how am I supposed to follow Allison's kind of Oprah-like interview that she had with Adam Gresham?
Maybe John is palpable.
I know, right? I don't know if John will be as warm and fuzzy to sort of give me that opportunity, but I guess I would just say I came into that discussion with him or Q&A session as his biggest critic and someone who is really looking to hear answers, about what his direction was, the modernization efforts that are underway, how he works with different agencies and departments to move them forward, and learned a lot and was very impressed with his answers. And so I find it to be a good match to sort of be one who hopes to keep a watchful eye on his work and the projects and how they move forward, but really respecting his competency at this point and what in his follow-up, and looking at some of the websites that were his favorite around the country. I think I also appreciated his focus on cybersecurity, which is something that we can lose track of, but we would know if it was going wrong. And so, that was really valuable to hear more about and know how much of a underlying passion that is for him.
Yeah.
Good. Yeah, I was impressed with, Go ahead.
No, I was going to say cybersecurity has been something he's been interested in from the beginning, and it's been a very big interest of his.
I have seen him grow a lot since he was first appointed and we first confirmed him. So.
Yep, he has.
Okay.
So I have recorded all of these. I missed who is reporting Beth Fastigi.
I am.
Oh, okay. Thank you.
Sure.
I will forward these to you, Keisha.
Thank you, Gail.
Mm-hmm.
All right. Did you move that we confirm him?
I move that we confirm John Quinn as Secretary of the Agency of Digital Services.
Okay.
Okay, Senator Clarkson.
Yes.
Senator Collmore.
Yes.
Senator Polina.
Yes.
Myself, Senator Rom, yes. Senator White.
Yes.
And we are advancing John Quinn for consideration by the Senate on a vote of 5-0-0.
Great. Thank you. Thank you. I think that, yeah, I don't know if other committees, what they've done, but I thought it was important for us to do it and just remove. So I did make a note here that sometime next year we really need to have a conversation, and I think it's our committee that should lead this conversation about what Senate confirmations mean in the long run and how we do that. So
is it just 4?
Yeah.
Oh.
It was just those 4.
So the one that you might have is the Commissioner of Public Safety in judiciary.
No, that comes here.
So why did we not have that?
I'm pretty sure that comes here. The one that might go to judiciary would be corrections. No, that goes to institutions. I don't know.
I don't know
why.
why. They may come up at different times, Allison, or he may just not have done it yet.
Yeah.
I don't know.
Yeah, it's just puzzling.
Well, I don't know. We'll just wait and see who we get and when we take them up.
Okay.
Okay. So committee, we are, I was hoping that we would have two things. We heard about the issue with the school board vacancy appointments before. So we had that conversation, and then we talked about the possibility of, if we come to any kind of a decision, of adding it to H-154, if there's anything we want to do. So I had asked Senate Education to weigh in on it, to let us know what their feeling was and how they would approach this. And we also asked the School Board Association to weigh in, and they were not able to come today. So I don't know that we have anything today that we can do, unless the committee has had other thoughts about where we might go. I don't know yet in my own mind whether we should even take it up, if we should just leave the statute the way it is, if we should recommend that it be done by the select board. I don't have strong feelings one way or the other. So, Brian?
Thank you, Madam Chair. So I know Ken and Todd have both joined us.
Mm-hmm.
They could give us an update as to what's happened, because I think there was a special meeting that took place in the interim since we talked about it last.
Mm-hmm.
So they could bring us up to date, first of all, and then tell us whether we need to do anything right now in terms of attaching this to a already existing bill. Because if we don't, there's probably, well, we could go looking for another vehicle, but I'm not sure we're going to find anything this year. So I don't know who wants to go first. But
I'll be glad to take it unless you want to go, Todd. Okay. Well, let's see. We testified, Todd and I and Lynn Edmonds and Robbie Congdon testified on March 19th to this committee. On the 22nd, the Clarendon Select Board had a regular meeting. Robbie reported out on the discussion we had here. And the Select Board decided to call for a special election. So the people of Clarendon would have a vote in the matter. So the timeline's a little bit funky, I guess would be an old white guy word I would use here. But the school board, Mill River School Board, was set to interview people on April 6th, this past Tuesday, and appoint somebody the 7th, last night. Well, the select board's timeline for the special election in May put the people had to put their petitions or their consent of candidates, they don't need signatures or anything, in by Monday, the 5th. So it was a day before the interviews and 2 days before. So basically, they called for a special election before they knew what the Mill River Board was going to do. But that it is what it is. The Mill River Board appointed a woman from Clarendon last night, and it all went pretty well, I thought. But that person is only going to be in that seat for 40 days, and unless she gets reelected. So the same two people that approached the Mill River Board are also on the ballot to be elected by the people May 18th. So I got a communication from Adrian Raymond, the chair of the Mill River Board, a little over an hour ago. And she said, I've been communicating with the chair of the Select Board, Mike Klopshin, the chair of the Clarendon Select Board. And it's all been collegial and very collaborative is the word she used. And no hard feelings. Everybody knows they're doing their own legal obligations. There was actually a letter sent asking the Clarendon board asked the Mill River board not to fill the vacancy. And they said, well, we can't do that. It's the law. And so they did fill the vacancy. And Mike and Adrian both agreed that this probably wouldn't be a problem if it wasn't so far out. The vacancy occurred right after town meeting. So it's going to be a whole year that this person, if it was a couple months or a few weeks, we probably wouldn't be sitting here today. So Adrian points out that seems to me, I'll read what she wrote here. Seems to me the law works as intended. The board filled the vacancy quickly. The town is represented. If the select board or the voters don't like the choice, they can warn an election. And I guess that timeline was a little, I think they jumped the gun a little bit calling for the special election, but that's my opinion. It's done. It's a done deal now. So she said, Adrian says all's good. You know, there's so my opinion is this is people are looking for a solution to a problem that does not exist. In any situation you care to name, any that I can think of, any governance structure of school boards or vacancy on a select board, the people of the town involved always have the last say. They can always petition for a special election. So town school district fills a vacancy. The people in that town don't like it. They petition the town school district board. Unified Union District school board has a vacancy. They fill the vacancy. The select board or the people of that town represented don't like it. They call for a special election and so on. Same with the select board. There's a vacancy on the select board. The select board fills their own vacancy. If the people don't like it, they can call for a special election. So that is a long-winded response to, I think the only thing that needs to happen is make 16 VSA, what is it, 706L B2, whatever, the one piece of school board vacancy law that keeps sunsetting for some reason. Make it permanent, as long as, as permanent as a law can be. But right now it's sunsetted after 1 year, then it's sunsetted after 2, and then 2 again. It keeps sunsetting. It seems to be working pretty well, and the other part of the law dates back 16 years, so that's been working well. We had a little hiccup here, but again, solution looking for a problem. Thank you.
Thank you. Thank you. Todd, you are muted.
My apologies. I have too many screens open. I think in general, Ken's description was fairly accurate. There were some tensions in the discussion prior to the vote regarding whether or not the school board members should defer to only the Clarendon school board representatives. This kind of comes back to one of the principal points that we discussed at the last meeting that you folks welcomed us into, and that being the constitutional roots of the problem. If we trace back to the Constitution is very clear, the state Constitution that is, that the voters of the town affected really should have the primary say. And that tension did show up in the board meeting last night, the school board meeting. Some of the elected school board members did defer to the Clarendon school board members, others did not. And therein, I think, lies the problem. To compound that particular problem, in the case of Mill River Union School District, we had an additional wrinkle in that the bylaws actually point back to the way things, I guess, used to be done in terms of an appointment being made by the select board of the town affected. So there was confusion there. That didn't really play too heavily into the discussion last night. But my takeaway on this is that all laws in the state theoretically should derive from the Constitution. And with that thought in mind, I believe it's Chapter 1, Article 8, which is very specific in its requirements to keep that linkage between the original voter and the choice of an appointment. So I do think that there's still some confusion as to really what is the proper course. If I had my say, I would prefer to see the select board of the town affected retain that control until a special election is called for. It just seems to me to make the most sense. Otherwise, we get into this situation of, who has the proper authority? Is it right, for example, for a representative from Shrewsbury to have say over a replacement for the neighboring town of Clarendon? I would suggest no. And I'm a Shrewsbury resident. So I understand where Ken's coming from. Fortunately, everything turned out reasonably well, but it might not have. I mean, there was definitely some underlying tensions there, some confusion. And I think the law kind of, as it currently is written, plays into that confusion. So I guess that's my 50 cents. Thank you for listening.
So could I just ask you, what article did you refer to in the Constitution?
Oh, bear with me. I'll look it up.
You had a reference to it.
Yes, it's Chapter 1, Article 8, and I'll quote it again: that all elections ought to be free and without corruption, and that all voters having a sufficient, evident common interest with and attachment to the community, so the key word is community here, have a right to elect officers and be elected into office agreeably to the regulations made in this Constitution. And I would gently add to that that's in the section listed as inalienable rights of the residents of the state. So there's a direct connection there between the community and their right to elect representatives of their choosing. So it seems to me that as it's currently written, the statute 16 VSA 706L bypasses that constitutionally protected connection between the original voter and a choice of replacement in the event of a vacancy.
Okay, Ken?
Yeah, Todd brings up a good point for discussion here. We've heard this a lot with this discussion. Admittedly, the unified union governance structure is a different beast than most because you have multiple towns, but those towns don't have individual school districts. So we hear quite often that Clarendon doesn't want Wallingford telling them who's going to represent Clarendon, and so on and so on. And that point has merit, but we don't hear, it occurred to me just recently, we don't hear the flip side of that. And I hope I can articulate this. It sounds pretty good in my head, so I'm going to try and articulate it for, what about the other way? We've got people from Wallingford and Shrewsbury and Timoth on the board, and they're representing their towns and their children. And now Clarendon, the select board, we're just talking vacancy. I'm not talking about elections, general normal elections, but the select board can then put somebody on the school board if this law were to change. And the other towns would say, well, this person doesn't have the best interests of the students in mind. So now the Clarendon Select Board, or whatever select board, is imposing their 5 people or 3 people belief onto the school district. And now the school district is like, what are we going to do now? We got this person thrust upon us. So it's a two-way street. Again, this does not have to be adversarial. As the law stands right now, the people always have the final say. There'll be a little lag time to warn a special election, but the Mill River Board, or any school board I've ever been associated with, and I was president of the VSBA board for a while, I've been around the block a couple times, they're going to appoint somebody that's going to upset the town they're representative or upset the other members of the board. They're going to find somebody who is interested in bettering the education opportunities for our children and keeping an eye on the bottom line for the taxpayers. So again, solution looking for a problem, in my opinion. I think it's working fine the way it is. It just needs to be made permanent. Thank you.
So I'm going to make a couple comments and then I'll ask committee members if they have any feelings. First of all, I'm not sure that your reference to the Constitution, there's no definition of community. And so it is the community. The community in this it refers to state elections, actually. I believe it's under the section called Free Men and Free Women, and it refers to the statewide elections, that they need to have an attachment to the community, meaning the state. So that is a different interpretation, but I'm not going to argue about that. I just think that That is the way I interpret that, given what we've heard from our constitutional scholars around the elections. And then secondly, I think that, first of all, we would not get rid of this sunset. That would be the education committee that would take that up. And my third comment is that since we don't have a pressing need right now, I would rather punt this to the education committee and let them deal with this issue and then come to us for suggestions if they want to involve the municipalities. I don't think we need to do this right now. That's my bottom line. So can I just ask other committee members if they where they are with this? Senator Polina?
I agree. I think that they've worked it out for now, and I think if we were going to take action on this, make a determination, we'd have to have a lot of conversation before we did that. So we're certainly not ready to do it now, and I don't think we're necessarily ever going to have to do it. But so I would say, giving it to education committee, let them decide if they want to move forward with it. Sorry, I'm so congested. I don't know if you can sound okay, but
is this from your shot?
No, in fact, we got my shots and that was fine. We went to visit our grandchildren and everybody's got their shots and all that. And my granddaughter gave me a cold.
You know what my doctor said when my kids started in kindergarten? He said, kindergarten is a cesspool.
Yes.
So Senator Collmore, you had a comment?
Yeah, I just want to make sure, we haven't heard from Robert Congdon yet, but as long as it seems the problem has been solved for the moment, I guess I will agree with the chair that we can sort of take a step backwards and just let things go the way they are. But I would like to hear from Congdon.
Yeah, I see he has joined us.
You want to pause before the rest of us respond?
Yeah, let's hear first from Robert.
Well, senators, thank you for having me. I apologize. My camera, for some reason, is not working today, so I do hope you can hear me at least.
We can.
Having a little bit of technical difficulties over here, but I'm not sure exactly what got said before I did jump on. I caught the tail end of Ken's comments and a couple seconds of Mr. Fillmore's. I would say at this point in Clarendon did take action to ensure that a special election was heard. We felt that was very important to maintain, the charge of this committee, even at the end of the last committee meeting, was to ensure that Clarendon's voice was not diminished in this process. So the select board unanimously made that decision. It was not split at all. Everybody felt that it was very important to give the townspeople a vote. And obviously, as long as that part of the law remains the same, any town that faced this issue would have that option if they so chose to go that way. I do continue to see the problem and while I respectfully disagree with Ken, the fact is that where I fall on it is a municipal vacancy, and in this case, I full-heartedly believe that a school district vacancy is a municipal vacancy, and that person is to represent the town that elects them. That's why I would continue to stand on that person should be appointed by the municipal elected officials, which is the select board. I know Ken's thoughts, I hear Ken's thoughts, but the other members of that board were not elected by our townspeople and may have different views than our townspeople. So the way to ensure that our townspeople's voice is protected and maintained is to make sure that it is representatives of the town that appoint that person. That's quite simply where I come down on the issue. Again, I respectfully disagree. I just feel that, we as a community, we as communities across the state, we all know that towns differ in opinions on certain issues. So in this sense, as a select board member in Clarendon, I was voted in to represent the Clarendon's town people. Those school board members that would be making that appointment were not elected in. There was a couple of them that were, but the rest of them are from neighboring towns. And that's the thrust of the issue. That's where it comes down. And the argument that, well, that person may not be in the best interest of the school board, we see that across the state in any election. A person could get elected to the select board next March that the select board wouldn't pick, but the people pick. That's the whole point of our democracy. So that's where I land on the issue, quite simply. And again, as an update, we did schedule a special election coming up in about actually it's a month, just over a month from this week. And the candidate consent forms were already due. They are already in, the ballot is set. And our clerk is working very closely now with all the process to make sure that everything gets done and the people's voice can be heard. So.
Thank you.
Okay. Thank you, Robert.
So could we hear from Senator Rahm and Senator Clarkson about, so all we're talking about now is whether we want to continue to look at this issue more and take it up, or whether we want to pass 154 as it is and have this issue addressed by the Education Committee. So that's our decision right now, is do we want to continue, or do we want to give this to the Education Committee and have them weigh in on it? So Senator Rahm?
Well, I don't know how the Education Committee feels about that. So, obviously that's some consideration, but I just feel every time I hear someone speak less qualified to make a statewide decision that would impact other communities from a situation that feels almost intractable from different perspectives, just from hearing people on some different sides. Now, I'm really grateful that they seem to have worked out a reasonable solution now, but I don't think we should impact this right now and have reverberations for other communities.
Yeah, and I don't know how the Education Committee feels about it either, but if it remains an issue about school board vacancies, it is probably more rightly addressed by the Education Committee than by us. We heard this and we thought, if there is something here that we could do, this is a vehicle for it, H-154. That's why we're looking at this. Whether the Education Committee ever takes it up or not is their prerogative. And so, Senator Clarkson.
Thank you, Madam Chair. I would agree. I think that from this particular circumstance, we're supposed to not make laws based on one particular circumstance. So I would agree that I think this belongs in the bailiwick of the Senate Education Committee. That being said, if we give this issue to them and they move on it quickly, they could also do it as an amendment to 154 if they thought it was appropriate, and we would agree. So, I mean, that's a possibility too. And if not, they could also address it. They have another year to address it in the course of this biennium. So I absolutely think this is something the Education Committee needs to weigh.
Yeah, no, and I've asked them to address it and get back to us, and have heard nothing. So whether they have any interest in addressing it or not, I don't know. But if they do, and they want to make a change, they can do that. But they could also have it on a separate bill. They could do a whole separate bill. If they want to get rid of the sunset, they can. Those are decisions that the Education Committee needs to make. Yes, Ken?
Yes, thank you, Madam Chair. I wanted to just clarify about the sunset thing. When I said it was my opinion to just get rid of the sunset, make it permanent, I did not mean this group here. I meant in general, it needs to happen in the legislative process somehow. I also wanted to apologize, kind of a la Senator Polina last time we met, that when you came back from break, he had said something that he thought maybe was a little inappropriate. And I described the word funky that I used at the beginning of this with a phrase describing myself that I used when I was writing a piece on equality in a earlier last year there somewhere, where I was saying, it was actually given to me by my daughter, says they don't need old white guys speaking for them. And I said, well, we can help them build the platform to speak from. So I hope I didn't offend anybody when I said that, describing myself. And because I am actually, but and also I'm wondering if we will be included, the four of us, if it goes to Senate Ed or wherever, will we get some sort of notification, or do we need to keep our eye on agendas?
Well, you're going to have to bring it to Senate Ed.
Oh,
I mean,
you aren't moving it. Oh.
We're not moving.
Okay.
If we vote on this bill today, we vote on this bill, and then that's the end of it. Whatever Senate Education decides to do with the issue of vacancies is up to them. And if you have concerns about how they should be addressing this, and I know there's a difference of opinion here, but Robert, if you have a concern that it should be the select board that does this and would ask them to make a change, you should bring that to the education committee. Because we've asked them to weigh in on it in terms of this bill, but they have not. And so now the issue with our committee would be over. And if
understood.
Okay.
Understood. Thank you for that. Thank you for that clarification.
Yeah. Senator Collmore?
Yeah, that's why I wanted to make it absolutely clear that you've already solved the problem right now, that we don't need to do anything, and that we can vote out 154 with clear consciences, knowing that you've already solved the problem for now. And whatever happens down the road, it would be up to your group, loosely put, as the chair indicated, to get a hold of Brian Campion, who is the chair of the Senate Ed Committee, and say, okay, for now it's taken care of. There's a special one coming up, but in the future, this is probably something we need to look at.
Yep.
That's all.
I expect we'll all be singing Kumbaya around the campfire any day now.
Okay, good. I'm glad to hear that.
All right. So committee,
Thank
given
you,
that,
yeah.
and I thank you all very much for coming again today and weighing in on this. I think this has been an interesting conversation, and I'll be curious to see if education does anything with it and what they do. So thank you.
Thanks, guys.
Committee.
Thank you very much.
Committee, can we vote on H-154? If you remember, H-154 simply says that if a select board member refuses to take their seat within a certain amount of time, then they can appoint somebody, and it comes directly from an issue in Wilmington where the person was elected and refused to take the seat, but there really is nothing they can do about it because he didn't take the oath and then resign. He just refused to take it. So, Senator Collmore?
Thank you, Madam Chair. I would now move that the committee votes out H-154 as it came over from the House with no amendments favorably.
And if anybody has any questions about it related to it, Tucker is here and can answer them if you don't remember.
So
okay.
If someone doesn't take their seat, this allows the rest of the body to appoint someone.
If somebody, the statutes are very clear that if somebody resigns,
Or dies.
then they can be, their seat can be filled. But there's nothing addressing if they refuse to take the seat in the first place. So somebody was drafted.
Right.
They were elected, and the person refused to take the oath and refused to take the seat. And so they're operating with two people.
So, sorry.
Senator Paulina?
So they would be appointed by the remaining members of the body. I'm just curious, though, this idea of doing special elections, that doesn't happen, Tucker? I mean,
not in this context. No. So the vacancy statutes for municipal offices state that the select board shall appoint the replacement.
Okay. Thanks.
Yeah. I also, if you have questions about how special elections may interact with any of this, Amarin should likely answer that question, but I was confused by the previous testimony about the special elections because
that's a school board.
Okay.
Yeah, we were confused by that too.
We're done with that. But yeah, currently select board, the remaining members appoint somebody if they resign.
So if there were like 3 members and 2 of them got sick or went away, the one remaining member would appoint 2 people to work with them?
So there are actually different replacement requirements when there is not a sufficient number of members to actually take any action. And that was a situation that recently arose, I believe, in the city of Vergennes, where there were not enough members of the legislative body to take action or to fill any of the vacancies. And they did have to hold a special election to fill council seats because both in theory and in statute, the legislative body has to actually be able to vote in a quorum or majority to take any action whatsoever, including filling those vacancies.
Yep. Thanks.
Which probably doesn't happen all that often, but yep.
Is this
anybody else? Yeah, Keisha?
Is this kind of a standard, but if a town decided, you know what, we don't want to do it that way. We want to have an election. Could they depart from this? Is there flexibility for them to do that?
There is the ultimate flexibility in that this is a Dillon's rule state and the General Assembly can give an individual municipality whatever they ask for as long as it doesn't violate the Constitution. So if a municipality wanted to have a separate procedure unique to their community for replacing an officer when there's a deemed vacancy, they could go through the charter amendment process and ask for that authority.
So this would be the default, but they could ask for.
Well, they could do a charter.
Okay.
And ask for it, but the fact that we tell them exactly what they can do and how they can do it, when they can do it,
right.
This is what they would have to do if.
Right.
Yeah. And this just, remember, all this does is addresses when somebody refuses to take the office in the first place.
So I'm actually thinking of a recent scenario around this and someone feeling like they were experiencing so much racial harassment during the election that they almost didn't take their seat. So,
but some of us worked really hard to make sure she said yes.
Yes. So I am running that scenario in my head and it's a unique one, but it's the one that has come up most recently in my experience with this. So,
it would be the same thing.
They would
just appoint someone to fill that seat.
Right. I guess I'm just thinking about it for a second, what that says, or if there's something else germane to this bill that would make us want to hold on to it and consider the reason someone would not want to take a seat.
I don't think it has anything to do with the reason why they don't take a seat. I believe that we need to give them the option to fill that seat, because what's happening in Wilmington is they're operating with 2 people.
Right.
Yeah.
And they need to have the ability to appoint somebody. And
right.
if somebody refuses to take their seat for whatever reason, the remaining members have to have the ability.
Right.
No,
I know. What if there's 4 people and 2 want to do one thing and 2 want to do another thing?
Oh, but
then they have to work that out. However,
have to come to consensus.
That would happen with any other issue also on a select board. If you had 5 members and you had one person who wasn't at a meeting and 2 of them wanted to do something and two of them wanted to do something else, it would happen in our committees. If somebody was absent and Brian and I wanted to do something and Allison and Anthony wanted to do something different and you weren't here. I mean, we can't cover every contingency. I think that we have to allow for there to be a process to put people in a seat.
Right. Right.
Did I make the motion again?
There's a motion on the floor.
Yep.
Yes.
I would call the question.
Okay.
Is there a reason we have to vote on this right now?
Well, I would like to get it. We have so many things.
We have a ton coming at us.
Yeah, we have so many things. I don't know why we would.
At us.
I can't think of a reason why we would not vote on it. I mean, if you can think of some circumstance that would say, no, we aren't going to allow the towns to do this.
Plus, in the situation you're thinking of, Senator Rahm, the person was going to not just not say anything to the board. She was going to say she did not want to serve. And so that would have opened a vacancy. This is
not unless she had taken her oath.
Right, exactly. Whichever. But I mean, she'd have done what needed to be done. This is very unusual circumstance where somebody hasn't taken the oath and they have just totally chosen to sort of tie the hands of the select board by not functioning as a select board member in any capacity. I mean, it's almost a little, well, I won't say that.
So you're saying that situation would be different because she'd take the oath and resign?
If she took the oath and resigned, there's already provision for that. It already says that they appoint somebody. That's already the law.
Okay.
Yeah. This is poor John Gannon.
What do you mean, poor John Gannon?
He's on that select board.
Oh, no wonder we're doing this, Bill.
I mean, it just seems to me that we have to, because it could happen to some other town.
Oh, it could. I think it's a good reason to move to 5 select board members.
No, I think staying with 3 is you can't have factions when you have 3 people.
Oh, yes, you can.
Oh.
Factions.
Anyway. Okay, so there is a motion on there to accept to report this out favorably.
Right.
Senator Rahm, would you like to call the roll?
Okay. Senator Clarkson.
Yes.
Senator Collmore.
Yes.
Senator Polina.
Yes.
Myself, Senator Rahm, I suppose yes. Senator White.
Yes.
Okay, that passes 5-0-0.
Would somebody
report it?
Okay, Senator Collmore will report. So just a question, Tucker. Was I right in my interpretation of the Constitution when I said that I thought that attachment to the community was not defined and in this context probably referred to the state?
Well, my ears definitely turned up when I heard that reference to Article 8, because Article 8 doesn't define community. And as far as I know, there's only been maybe 9 or 10 Supreme Court cases in Vermont that have even looked at that article, and none of them have looked at what community means. But the presumption is that it is the state. It's about the assembly. And, the counter argument to what was being discussed earlier is that the community in this case is not the individual municipalities in the district. The community is the district, right? That's who the voters are attached to in this instance. Anyway.
Oh, interesting.
Thank you. Sorry about that. Yeah, I think you're right. That's what I thought. Okay. All right.
But while we're on this, I'm looking at it. Where is the definitions section?
Definition of what?
Community.
There is no, you don't have a definition section in the
That's what
Constitution.
I was just wondering when you said, I was wondering, well, where is everything else defined?
I've looked for the table of contents for that bloody thing forever, and I never could find it.
What,
It's
Article 8?
Joking.
Article 8.
Oh.
Article 8.
He's looking for definitions too.
No, there aren't definitions. Think you have to look at the definition within the context of where it's placed in the Constitution and where, and I mean, there's no definition of resident. There's no definition of militia. There's no definition of private property. I mean, you don't.
There's a definition of voter.
In the Constitution.
Yeah, there's a definition
of what?
Voter. There are express voter qualifications. So everywhere where the term voter appears in the Constitution, you know exactly what a voter is.
Right, but it's not in a definition section.
Right. I've been looking for the definition section and it doesn't exist.
I don't think I've ever seen definition section in any Constitution.
I know, I'm just joking, but
okay.
It's interesting because, well, anyway.
So, okay. So committee?
Yes.
Are we
walking into? Damien, before Tucker leaves, we have another subject that I think, I have a meeting in about 20 minutes, so I've got to scoot.
I do too, but what else did we have on here for today?
Oh, the thing about the transportation people?
Something is happening. Okay.
But Tucker, there are other people coming. Look, Mark Anderson's back. Damien's back. Brett Meyer.
Madam Chair, you requested a walkthrough of S85.
Oh, okay. All right. Let's do it.
Okay. I'll email you, Tucker.
Okay. Sorry. I'm sorry. We didn't have to prolong that conversation. I completely forgot. I hate this trying to schedule things on Zoom. I hate it. But anyway, okay. Thank you. Damien, would you like to walk us through S85?
Sure, I'd be happy to. So I think this should be up on your website. If I remember right, this committee does not like it when I share my screen, so I won't do that.
Right, and it is on our website.
Yeah.
So the bill from a textual standpoint is a very simple bill. And I will let the advocates tell you whether it's a simple bill from a policy standpoint. But if you look on page 1 of the bill, lines 19 and 20, what this would provide is that the transportation deputies in the sheriff's departments would be designated as state employees within the classified service as defined pursuant to 3 VSA 311. Currently, those transportation deputies are not designated as state employees, although they are paid by the state of Vermont with their salary at least ostensibly approved by the governor. So this would change them to individuals who are paid by the state of Vermont and employed by the state of Vermont, although their assignment as far as which county they were serving in would be determined by the executive committee of the Vermont Sheriff's Association and the executive director of the Department of State's Attorneys and Sheriffs. The reason why that change is significant is because classified employees are allowed to collectively bargain under the State Employees Labor Relations Act. You'll remember a couple of years ago, we had a similar proposal which basically created a new bargaining unit for employees of the state's attorney's offices statewide. The way this bill is different is it simply designates these employees as these transportation deputies as classified state employees, which means they could potentially be integrated into an existing statewide bargaining unit without the need for us to designate a separate bargaining unit. And that's where I'll leave off. That's the walkthrough. Do you have any questions for me before you get to your witnesses?
Nope. Anybody else?
Okay.
Anybody have a question? Okay. So I think that first, I think we'll go to Steve Howard and then to Annie Noonan. And then Mark and Roger are here, sheriffs are here too. And my, okay, let's just go. Steve, do you want to give us a quick rundown of why this is important and why we're doing it this way?
Sure. Thank you, Madam Chair. For the record, Steve Howard, I'm the Executive Director of the Vermont State Employees Association. And I just want to point to the committee's, make a point to the committee that I think I just barely sent to Gail a letter from the transport deputies. There are currently 21 transport deputies with 4 vacancies, and all of the current transport deputies have signed on to a letter in support of this legislation. So there's widespread support among the transport deputies for this change. And the reason for it is that the state of Vermont currently, the VSEA currently negotiates with the state of Vermont for pay and benefits that our members receive and that are given to these deputies. So for instance, they receive the same COLA that we would receive, that our members would receive, but they have no voice in the process that determines how we get to that conclusion in the collective bargaining process. And they would like to participate in that voice, in that process. So this is very simple. It just simply says that we're going to allow them to be for the issues that the state has interest in, their pay, their benefits, all of those matters. They would be, like any other state employee, allowed to collectively bargain, and they would be allowed to be. They would be added to an existing bargaining unit. In this case, probably the non-management unit, where the rest of law enforcement is. You know, our DMV police officers, our fish and game wardens, are all in the non-management unit, with the exception of our state police lieutenants, who are in the supervisor unit. So this bill would work very much like the employees that we represent in the state treasurer's office or the Secretary of State's office or any of the statewide elected officials, where we're bargaining with the governor for the employees who are supervised by these statewide elected officials. So there's sort of like a joint employment arrangement where they would be supervised by the sheriffs, but they would be bargained, their benefits would be bargained with the governor, just like, you know, an admin assistant in the treasurer's office, or an investigator in the attorney general's office, something like that. So it's very similar to that. As I said, I think I've already said that just to make it clear who we're talking about, the transport deputies are the deputies who are paid by the state. They are in the state retirement system. They're in the state healthcare system. These are the folks who transport those who are accused or who are convicted between the facilities that they're held at and court dates. They also transport folks who are suffering from mental illness and are moving throughout the system in the state, and are often called upon to transport youth throughout the state to various facilities. And so I'm also joined by Lieutenant Mark Poulin, Madam Chair, and if it's okay with you, I don't know if this would be appropriate time or you want to talk to him later, but he is available to tell you why the transport deputies want to, why there's so much widespread support from the transport deputies for this change.
I think what I'll do is jump to Annie Noonan first, from the state's attorneys and sheriff's department, because I think that there are some issues around the way it's constructed, and I'd like to hear what those are and where we would go with it. Annie? Okay. And you are muted, Annie. There you go.
Thank you very much. Good afternoon, Senators. Thank you for letting me sub in for John, who is homesick with his COVID shot. For the record, Annie Noonan, Director of Labor Relations and Operations for the Department of State's Attorneys and Sheriffs. I want to start out by saying that neither the department nor the sheriffs are speaking out against employees' rights to self-determine whether they choose to be unionized. The concerns that I will raise through this discussion today will become evident as to what some of those issues are. And also, for the record, I want to point out that in 2017, this department supported S-131, which allowed the employees in the state's attorney's offices to unionize, to unionize, and then we successfully bargained a first contract with those employees. So this is the issues that I'm going to raise, I hope, are heard from the perspective of which they are offered, insofar as the fact that there's both the sheriffs and I have spoken at length, and there are some issues, and I will go through them. So as you know, the construction of the 14 elected sheriff's offices is a mix of programs and funding, and it essentially replicates a public-private ventureship. The State of Vermont General Fund pays for the salaries and benefits of the 14 elected sheriffs and for the 25 state transport deputies. In addition, the department pays for the mileage and the per diem deputies who may work in place of a transport deputy. Those individuals work for the sheriff's office when those people perform transports. And our folks do transport from the correctional facilities to court or on extraditions, and they do some other duties, which we can get into at a later date, but it's not relevant to today. We also pay the state worker comp premiums for the sheriffs and the transport deputies, and a portion of the audit work that is contracted for by the state auditor. S85 changes the status of the 25 state transport deputies to make them classified employees under Title III, Section 311. And in proposing the change, VSEA has been informed by VSEA has informed the department that they would then like to put this transport deputies under the existing non-management unit contract. So VSEA would need to petition the Vermont Labor Relations Board to include these employees through either a unit clarification process, which seeks to do so potentially without a representation election. The board could agree to that petition, or they could decline to do so without allowing the employees to decide. The board considers factors including the self-determination rights of the employees, labor relations, and the protection of bargaining in the public sector. The VSEA could also seek to add the employees to accretion, whereby new employees whose work and interests are aligned with those in an existing bargaining unit can be added to the bargaining unit. So the board will be involved in this process. But in either situation, whether it's a unit clarification or an accretion, neither the State Department of State's Attorneys and Sheriff's Department, SAS, nor the sheriffs have participated in the contract provisions that would potentially cover the state transport deputies if they're incorporated into non-management or another bargaining unit. The department has not budgeted for these costs that could be associated with the change, and the sheriffs have also expressed concerns about the possible impact to their own budget, since they provide substantial in-kind support, including cars and uniforms and other equipment. And in addition, the sheriffs have raised a concern about their ability to exercise their authority to appoint a deputy under 24 Section 290. So for those issues, for the fact that we are concerned about, in essence, having to administer a budget under a contract that neither the department nor the sheriffs have had any input into, how these would play out for these employees would be a problem. And I will just say that I think many folks have heard me talk about the fact that the first contract is usually, those expenses are such that we worry about the absorption. I spent over an hour and a half this morning on the phone with our budget analyst talking about the first contract impact to our budget this year. And, I look at what that potentially is, and it's close to $400,000 that we will be absorbing currently in our FY21 budget, and trying to make my case for additional money in the Pay Act to cover the cost of that first contract. So these issues aren't simple from a financial perspective. And, what that means for the department is just starting with a hole. And I think that we look at the sheriff's budget for next year, and we have had to cut $160,000 out of mileage and per diem costs. So moving people into this without any ability for the department to budget, and becomes problematic without the sheriff's issues being addressed in terms of their statutory right to appoint people and to take those appointments back can become a problem. But I'm just laying those issues out because I'm living it right now with the unfunded mandates of the first contract that was collaboratively negotiated, but for which we don't have money to absorb those costs. So those are some of the concerns that I lay out from the department's perspective, and we'll leave it for. I know you've got a lot of other people behind me to testify, so I just will put those issues out there.
I'm going to. I know that a number of us have another meeting at 5:00, and so I really apologize to people. What I'm going to try and do is, in my own mind, wrap myself around the issues here. When we had this state's attorney's employees unionize, the negotiations that they did were with the Department of State's Attorneys and Sheriffs.
Correct.
Because that's their employer. So what we're doing here is we're saying that the employer, who is the sheriffs and the Department of Sheriffs and State's Attorneys, will have no negotiating ability here at all. They will be in another unit, another bargaining unit, and the actual employer won't have any ability to negotiate. Is that the way I'm reading this?
It's a possibility. Depends on how, if the SEA if this bill passes and VSEA goes to the labor board and receives a unit clarification go ahead or accretion go ahead quickly, and they put them in non-management, I presume VSEA's position would be, and I'm sure what they've discussed with the transport deputies, is that they would have certain benefits that would be under the non-management bargaining unit. And so in that existing contract, that is correct, that the department and the sheriffs have had no input into provisions that would potentially impact those employees. Now, in future negotiations, we could request to participate with the Department of Human Resources to have them present proposals to us, or vice versa. But again, it's part of the larger bargaining unit, and we would be one small group of managers who would have interest in what happens to a bargaining unit that covers, over 45 or 4,800 employees. So it is certainly possible, that we could be talking with DHR in the future for input into the contract. If in fact this happens so that the employees are just absorbed under non-management soon, and those benefits accrue to those employees, then that is correct, Senator. It would be benefits and provisions for which the sheriffs have had and the department has had no input.
Okay, I did see that Steve's hand was up and he was shaking his head. Senator Clarkson, did you have?
No, I'm having to depart, but I look forward to the continuation of this conversation.
So what I'm going to suggest is that, given the fact that a couple of us have another meeting we have to be at, and I, again, sincerely apologize. I'm so sorry. I just spaced this out. That we continue this conversation. And I will say pretty bluntly that I'm not sure that this will go anywhere this year. We are well past crossover, and we would have to get permission from the Rules Committee to even bring it out of our committee to get it on the floor. And even if we were to do that, the likelihood that the House would take it up with this little time remaining is pretty unclear. So what I'm going to suggest is that we set up another time where we can really look at this and see how we can work out the issues here and hear more from, because I know Steve had his hand up and Mark wanted to testify also, and hear from the sheriffs in addition. Does that make any sense, committee? Because I don't want us to try and rush through this. Okay. Senator Rahm, are you okay with that? Okay. So I will schedule this again, but I will say that it is highly unlikely that this would make it through the Rules Committee. I mean, the things that are going to make it through the Rules Committee are things that have some time constraints around them and are seen by the Rules Committee as needing to have action this year. So, but we'll set up some more testimony on it and try and figure out what those issues are and how they might be resolved. Does that make sense?
Yes, thank you, Senator.
Thank you again. I sincerely apologize. We'll see what I can screw up tomorrow.
Right.